Okay, thank you all. Well, I hope everyone enjoyed lunch and had fruitful discussions about what you've heard so far throughout the panel discussions. We will now hear from Ernie Lanza, the MSRB's Chief Regulatory Policy Officer. After Ernie's remarks, we will move into panel 3 on avoiding acting as an unregistered municipal advisor, where certain exclusions will be highlighted for a refresher and a discussion of public-private partnerships, among other topics. I'll now turn things over to Ernie.
Hey, everyone. Oops, sorry about that. Thanks for coming back for the second part of the day. Hopefully it'll give you a chance to settle down before we get started with the interesting parts, which are the panels themselves. But again, as Bree mentioned, I'm Ernie Lanza. I'm the Chief Regulatory and Policy Officer at the Municipal Securities Rulemaking Board. We are thrilled to once again co-host this event with FINRA and SEC, and it's great to be able to be back at least partially in person with this hybrid event. It's really gratifying to see really a full slate of folks here. We even have an overrun room, and I know we have lots of people online as well. So I think it's really gratifying that we have people really paying attention to these issues, which are really important for the marketplace. I'll talk a bit now about what we've heard before. We had two real good panels on MA disclosure and off-channel communications. These are two areas where there's been lots of very focused attention in the marketplace, with market participants trying to understand, where the lines are, what the requirements are, how best to comply with obligations that exist in that area. I think as we go forward, we're going to continue to have a mix of very focused panels where we're able to kind of look and see at particular issues that are important to market participants to understand, as well as some broader views as to kind of exam priorities, enforcement priorities in the future, other pain points in the marketplace. I think you'll continue to see some really useful panel discussions that'll really get to some of the core issues that face both BDs and MAs in the municipal securities marketplace. I think most of you are municipal market practitioners, and I think most of you appreciate the fact that munis are a bit different for those who kind of have 1 foot in munis and 1 foot not in munis, or most of their feet are in muni and outside of munis and want to all dabble in. It can sometimes seem like a strange marketplace with strange practices and strange regulations. It really is a matter of kind of the nature of this market, and that's why a lot of the regulatory approaches are very tailored towards this market. Clearly some of the key differences that make a difference to the MSRB in terms of how it goes about rulemaking is one, the nature of the market itself. And I think most of you know this, 50,000 or more issuers, 1 million different securities. Trading in bonds tends to be much, much thinner than they are in exchange traded securities. And so it's a very different process in the marketplace that requires kind of a very tailored approach to how regulation works. And then in some ways, maybe the bigger distinction, although that's a huge distinction in and of itself, is that we have a very tailored, from Congress, a very tailored structure of regulation in the municipal marketplace versus other markets, securities markets, so that, certainly the MSRB, as well as FINRA, to the extent that you are FINRA members, and the SEC having overarching responsibility, have regulatory authority with regard to broker dealers and MAs, and that's what we're talking about here today. But the big challenge, of course, is that unlike other markets, we don't have that hand-in-glove regulatory structure where you have a series of broker dealers and advisory rules that kind of work in a kind of integrated way with other regulatory aspects of other markets, where issuers and other market participants also have regulatory obligations, and so they can kind of together work to achieve kind of key investor protection goals. In this market, the regulators need to achieve those same types of investor protection and with municipal advisors, issuer protection goals, using a smaller set of a smaller toolbox that's available in other marketplaces. And so we look to achieve reasonably consistent investor protection and issuer protection using fewer tools through the process of broker-dealer and MA regulation. The other point I'll make, and then I'll stop talking, we can move on to the interesting panels, is MSRB and certainly FINRA as well, although I'm not going to speak for FINRA, we're thought of as self-regulatory organizations. And that's obviously the right terminology. And the main obvious reason why we're self-regulatory organizations is because we have boards, or MSRB, I'll speak about the MSRB. The MSRB has a board that is made up, at least in part, of regulated entities who can provide that insight into kind of how these rules work in practice, and what makes sense in the context of the marketplace and the structure of the market. This is a choice Congress made to have that kind of participation by the regulated community in the rulemaking process. But it's also very much a self-regulatory structure. And I think that should have come out from the discussion, even in the first two panels. The importance of things like written supervisory procedures, internal processes. The fact of the matter is the way regulation works here is that there are a series of rules that regulators write. They can sometimes be prescriptive, sometimes be principle-based, or somewhere in between. But at the end of the day, one of the core responsibilities for a well-regulated, safe marketplace is for each broker-dealer or each municipal advisor to put in place the required written supervisory procedures and the processes to comply required in our rules G27 and G44, so that in effect, each regulated entity is doing its own self-regulation. They set they understand what they need to put in place in order to ensure compliance with MSRB, SEC, FINRA rules, any applicable rules that apply, and say, for the nature of the business we undertake, for the products we take, for the types of customers or clients we have, these are the right processes to do day-to-day work as well as supervise that activity in order to get our firm to be in reasonable, in compliance with those provisions. And that self-regulation through your policies, procedures, and supervision is not just a one-time done and yeah, we'll put it on the shelf or maybe we'll follow it, but it is an ongoing obligation to review, and it's necessary to revise as rules change, as market changes, as product mix you deal with changes. All those things, it's a living document and a living process. And so it's important to keep in mind that sometimes it gets frustrating to saying, oh, well, someone's looking over my shoulder and saying, these are the processes, procedures you have in place, and why is it so important to have such levels of particularity within each firm, is that the trade-off is that as opposed to having rules that are very, very prescriptive across the board for all market participants, regardless of the nature of activities, they are contoured to your activity. But because that is such an important part of the regulatory structure, is something that the regulators will always be focused on to ensure you have policies and procedures that make sense, you have a system of supervision that makes sense, and you follow them and you keep them up to date. And so again, the first two panels, you heard quite a bit about that. You'll hear a lot about that going forward. And so I think it's helpful that you keep in mind that the self-regulatory structure of the municipal marketplace involves you as a self-regulator of your own activities. So with that quasi little lecture-y Tony thing, I'll turn it over to Abamola and her group to start talking about things that you actually have interest in. Take care.
Welcome, everyone. So this is our wonderful panel 3 right after lunch. Please stay awake. Avoiding acting as an unregistered municipal advisor. I'm the moderator of the panel. My name is Abamola. I'm a director at the Market Reg MSRB. I advise the Chief Regulatory and Policy Officer on legal and policy matters relating to the MSRB's rulemaking, compliance support, and regulatory coordination initiatives. And I will turn to my wonderful panelists so they can introduce themselves. Phil?
Thank you. I'm Phil Goopman. I'm a senior principal examiner at FINRA. I've been in the real world business, as they say, for 35 years. I was an underwriter. I managed a fixed income trading desk, and I've been at FINRA here for about 9 years.
Good afternoon, Emily Metzler. I'm with Municap. We are a registered municipal advisor, and we focus in the area of public-private partnerships. And I'm pretty sure that they put me in the after lunch slot because I get pretty involved in this topic. So I'll keep you on the edge of your seat.
Good afternoon, Blake Morris. I'm at Hilltop Securities. We're a duly registered broker-dealer, municipal advisor. We also have investment advisory business. And my role, I run supervision for our banking practice.
I'm Mary Simpkins. I'm Senior Special Counsel in the Office of Municipal Securities at the SEC. I've been at the SEC since Arthur Levitt was chairman. And before that, I was in private practice where I focused on municipal bond and tax work.
Thanks, everyone. Wealth of knowledge. I'm already feeling intimidated, but let's start. So we plan to cover a lot today. We're planning to cover areas that will help the municipal advisor, BD firms, and duly registered BDMA firms and individual within these firms to be aware of which activities potentially subject the firm to the registration requirements and why and how. We'll also focus on certain gray areas where the source of common confusion in the industry, including areas of confusion when it comes to the statutory exclusions or regulatory exemption in this area. We'll cover some recent enforcement actions and give you some takeaways at the end. I do want to note that we got a few questions, the pre-submitted questions for this panel, about 4 to 5. So we've already built those in. We'll try our best to get to all of them. There's a chance we may not get to live questions, but if there's time, we'll try. If not, please still feel free to reach out to us to get additional guidance. So I'll start with just the introduction, the definition of municipal advisory activities, a brief overview of the statutory definition. So the Dodd-Frank Act requires persons act as municipal advisors to register with the SEC and the MSRB. The Commission adopted final rules for municipal advisor registration, which, among other things, interpret the statutory definition of the term municipal advisors, the statutory exclusions from that definition, and it provides certain additional regulatory exemptions. The statutory definition of municipal advisor is very broad. A threshold analysis a firm must undertake in interacting with municipal client is whether any of its activities fall within this definition of municipal advisors. So I know you've heard this from the earlier panels too, but just to reiterate, the term municipal advisor means a person who's not a municipal entity or an employee of a municipal entity that provides advice to or on behalf of a municipal entity or obligated person with respect to municipal financial product or the issuance of municipal securities, including advice with respect to structure, timing, and terms, and other similar matters concerning such financial products or issues, or undertakes a solicitation of municipal entity or obligated person. So most people know that the term advice that used here is broadly construed. The SEC has explicitly stated that the term does not lend itself to a bright line test. It's all about relevant facts and circumstances. This is more of an activity-based rule. So if you perform certain activities that are ME activities, you fall under the rule regardless of your primary focus of business. With that said, I will turn to Mary to possibly go over some of the major exclusions and exemption in this area to the MA registration rule to get started.
Well, thank you. The Dodd-Frank Act had 5 statutory exclusions in it. And then in our final rule, we added 8 regulatory exemptions to the definition. So I'll briefly go through those, and then we'll talk about a few of them in a little more depth. So the 5, and keep in mind, these are activity-based exclusion and exemptions rather than status-based. It doesn't matter what you're called. What matters is what you're doing and are you conducting municipal advisory activity. So just to go through the exclusions that were in the statute. The statute specifically excludes a broker, dealer, or municipal securities dealer serving as an underwriter, attorneys providing legal services that are of a traditional legal nature. Now, we recognize there is a financial component there, but it does not cover attorneys who are holding themselves out as legal experts or structuring financings. If you want to do that and you're an attorney, you can register. There's a statutory exclusion for engineers providing engineering advice. But again, that does not cover advice on the issuance of municipal securities or municipal derivatives or advice about how to finance the engineering projects that they have discussed. There's an exclusion for registered investment advisors who are providing investment advice pursuant to the Advisors Act. There's an an exclusion for registered commodity trading advisors who are providing advice related to swaps. Then on to the regulatory exemptions that we provided in our final rule. There's an exemption for accountants providing audit or other attest services. There's an exclusion for public officials and employees to the extent they act within the scope of their official capacities. There's an exclusion for swap dealers registered with the CFTC, as long as they are not acting as an advisor to the municipal entity. Responses to RFPs or RFQs, we'll talk about this a little bit more, but this covers any person providing a response in writing or orally to a request for proposals, provided that such person does not receive separate direct or indirect compensation as part of the response. There's an exemption for banks with respect to certain identified banking activities. There's an exemption when there's participation by an independent registered municipal advisor. And the main thing to remember about this, it's not just does the issuer have an advisor. They may have posted on their website, yeah, we have an advisor. There are several requirements that must be satisfied to perfect this exemption, which we'll talk about a little bit later. So keep in mind, if you don't have this in your policies and procedures, you may need to review the rule, and that goes for everything in the rule. As was pointed out earlier, the rule is very extensive. We put out a lot of guidance. It's hard to remember all that. I mean, I worked on it, and I have to go back and review what's in there. There's a lot of material, a lot of guidance that's good. So make sure you're reading everything. Then there are two exemptions that relate to persons that provide advice on certain investment strategies that are not plans or programs for the investment of proceeds of municipal securities or the recommendation of and brokerage of municipal escrow investments. So it doesn't apply to all the monies that a municipal entity has. It only relates to bond proceeds or the recommendation and brokerage of municipal escrow investments. So in terms of investments and also in terms of solicitation, we're talking about those certain types of monies. So I'll talk a little bit more about the underwriting exclusion. There are a lot of activities identified as within and without in our release. I mean, they generally includes advice with respect to structure, timing, and other similar matters, but it only applies for the particular transaction or a particular issuance of municipal securities through the end of the underwriting period. If the underwriting period is over, this exemption or exclusion no longer applies, but the broker dealer needs to take into consideration, am I providing advice at all? But generally it has to relate to a particular transaction. And there are a lot of things that are in or out, but let's talk about a few of the things that are out. It does not include advice on investment strategies. Investment strategies are, again, it relates to the investment of proceeds of municipal securities, the recommendation and brokerage of municipal escrow investments. Doesn't apply to derivatives. It doesn't apply to the method of sale, competitive or negotiated. It doesn't apply to advice on whether the entity should approve or authorize an issuance of municipal securities. It doesn't apply to advice on a bond election campaign. It has to be specific to that particular issuance. Doesn't apply to assisting issuers with competitive sales. It doesn't apply to preparation of financial feasibility analyses with respect to new projects. So those are some of the things that we have identified in the release. Going on to the exemption for RFPs and RFQs, the municipal entity or an advisor acting on their behalf conducts the RFP or RFQ, a particular objective is identified, it's open for a specified period of time that's reasonable, and it involves a competitive process. If you are responding to an RFP, you are generally, you're allowed to give advice because they're the ones that ask you. So, and I think we may have had a question.
Yes, so we did get a question on RFQ, RFP. Any guidance when responding to an RFQ, RFP if an advisory service appears to be left out of the scope of work? And the example given was such as post-pricing analysis.
I did not give my disclaimer at the outset. I would probably be a good time, because I'm not even sure I totally understand the question, but here I'm going to take a stab at it. They forgot to include, I'm sorry, could you repeat the question again?
Sure. Any guidance when responding to RFQ and RFP, basically if an advisory service appears to be left out of the scope of work, such as a post-pricing analysis?
Generally, with an RFP, you need to be responding to what they ask you. You can't just make up questions and answer those, because if you assist with an RFP, that could potentially be municipal advisory activity, because then you could just make up whatever question you want and then answer it. If it's fairly implied from what is sent to you, then I think it's fair to respond. And also with respect, I mean, we would want to encourage post-pricing analyses. So if you're talking about an underwriter here, like it's after the underwriting period and the underwriter's doing some kind of post-pricing analysis, I think that would be permitted under the underwriting exclusion because it relates to that financing. But I would just say that particular issuer might want to also check with their municipal advisor if they have one, or do, the underwriter would not be an independent source of information on that topic.
And if I could add just a couple points of perspective from maybe a practice. One, during the RFP, RFQ response period, there's an exclusion for generally providing advice as long as there's no compensation. So I think, to the extent, as a municipal advisor, I'm providing additional information. One point I would say is it may set a municipal advisor or even an underwriter apart that you want to take your response to the next level and say, well, maybe this is something that you need to consider in your scope. So maybe you do want to add that into the response, but it might be worthwhile to go back to the issuer of the RFP and RFQ and ask that question, if I can include this, if it wasn't initially included in the RFP or RFQ. I think your point, sticking with the intent of the RFP and RFQ is valid, but I do think that in practice, there is an exclusion in that response period that you're not necessarily providing an advice, and sometimes going that one step further to provide information that shows experience is helpful.
Thank you both. I think, Emily, let's stay with you and talk a little bit about activities that may trigger the MA registration requirement. So given your work centers around the public-private partnership, most commonly known as P3, I'm curious about the areas of confusion when it comes to the P3 area as to what are those activities that are triggering this issue.
Sure. So I always like to clarify, there's, in my world, I talk about P3 in two different forms. So there's P3, that's traditional 3P, and then there's P3, which is public-private partnerships from developer, municipal, issuer. I work in the space that is issuer, developer in the world of real estate development, P3, which is, both are challenging in their own right. But what we find is that local governments are increasingly looking for ways to redevelop and issue bonds and find unique forms of revenue to, maintain sustainability and support, more economical land use across their jurisdictions without having to put that tax burden on their municipality. And the way that they're doing that is finding unique ways of financing that: TIF, special tax, special assessment, designer revenues, and that's coming through these public-private partnerships. And that's where we're the space that I've been working in for the last 20 years. In that space, we think about it in multiple phases of work, and I want to break down those phases in a little bit more detail. I think many municipal advisors or parties working in this space think it's very clear that municipal advisors issue bonds, and that's municipal advisory activity. But the work that we do, we break it down into 4 phases. Phase 1 is the financial planning phase, and I'll go into a little bit more detail about this. Phase 2 is the governmental approval phase. Phase 3 is the issuance of bond phase, and I think most parties here know that phase. And phase 4 is the post-bond issuance phase. 3 of those 4 phases, I think it's unclear still, and there seems to be a misunderstanding as to where parties need to be registered. And I think in the world that I am working, I run into other consultants or other advisors or non-traditional MAs who aren't registered. Mary talked about exclusions or other parties, and the definition for a municipal advisor. And, purposely the definition for municipal advisor was broad, and so that it captured many parties. And I think that was thoughtful and had intent. But at the same time, it also left open for interpretation many non-traditional parties the ability to determine on their own right that they did not need to be registered. And so when you look at these other 3 out of 4 phases, which I'll go into some, scope items and fact patterns on, I think in my interpretation and in my practice that there is a need to be registered, and we're seeing that municipalities and bondholders in particular are at risk because those parties are not registering, and the education and clarity on the scope of services just needs to be, further defined or further clarified out there. And I think we're seeing that now as there's, a much bigger focus on public-private partnerships and as it continues to grow in this industry. So just to kind of go through a little bit of those fact patterns or scopes from those areas, in preparing a plan of finance, the work that we do consists of evaluating different revenues that are available to repay bonds. That can include preparing revenue projections or revenue reports. We also look at structuring of bonds. We're looking at qualified costs that we're going to spend the bond proceeds on. We're looking at preparing a fiscal impact analysis to determine whether or not a municipality can give up those revenues and still cover their costs of services and pledge them to certain bond proceeds. We're also looking at gap analyses. We're looking at a developer's pro forma and determining whether they have a gap. All of that translates back into public policy issues that are important to municipalities. That's all just in the financial planning phase. And when you put together those 4 constraints, looking at revenues, looking at what you're going to spend the money on, public policy issues, how you're going to spend the money, whether there's taxable, tax exempt issues, we do normally leave that up to the attorneys. Those are areas that I consider advice, because ultimately it's going to lead into how you're going to structure the bonds. But you have entities out there that are preparing a revenue study or preparing a fiscal impact analysis, and they do that on a side study. But what they don't realize is that is going to be utilized down the road by that municipal entity for the purpose of making a determination or a recommendation for structuring debt down the road. When you get into the governmental approval phase, this typically relates to how the bonds are going to be issued, how they're going to be used, how they'll be secured and structured. I mean, we're talking about a bond authorization resolution, a district boundary authorization. If you're having any assessment methodology like a special benefit rate and method of apportionment approved or the pledge of revenues approved, all of those approvals get done in that phase 2. And in my mind, this is an MA activity because it's a call to action. You're literally asking the governmental entity to approve these actionable items because their intent is then to go issue bonds. So if you are helping prepare a rate and method of apportionment or advising on how many parcels need to be in a district, because, oh, by the way, this number of parcels is going to get divert revenues away from your general fund in the future, if it's in a TIF district, as an example, that means that those revenues are no longer flowing to the general coffers of your municipality. That's an important risk factor for a municipality, and I think that that is specific and a recommendation and can be construed as advice. I'm going to skip phase 3, issuance of bonds. I feel pretty comfortable that we have a good handle on that phase, and go right to post-bond issuance efforts. This is a phase that I think is most commonly misconstrued, and I see many advisors and consultants working in the post-bond issuance phase. There are about 6 to 8 key categories of work that are done in this area that I believe consultants are not clear on whether that or not they need to be registered as a municipal advisor in doing this work. A lot of it, the first panel this morning around continuing disclosure, 15C212 reporting, whether or not you're assisting with continuing disclosure, if you're assisting with the reporting and pledge of revenues for an assessment role in the levy and billing and collection of those revenues, if you're doing requisition review, arbitrage, rebate, IRS compliance monitoring, if you're assisting with investment of bond proceeds, indenture flow of funds, account statement reconciliation, bond redemptions, if you work in a state that has homeowner districts and you need to assist with homeowner inquiries. These are all services that you as a post-bond administrator can be hired to assist with. And while many of those post-bond administrative services agents say that we are just following what the documents tell us to do, I can tell you, as somebody that works and helps administer over 300 districts across the country, those bond documents are not always clear. And sometimes we are left to have to interpret those documents and have conversations with attorneys and issuers where we are reading them and saying, well, what was the intent of that document? And in that moment, we have to look to the issuers, we have to look to the bondholders and the trustee and have a conversation and be able to interpret them. And in those fact pattern moments, we are having to provide advice. And so in that moment, I think we're crossing the line from gray to now black and white, that we are a municipal advisor providing advice. And so, when I look at all those scope items, I find that 3 out of those 4 categories, financial planning phase, and the governmental approvals and the post-bond issuance, those seem to still be great for me.
Thanks, Emily. That was actually very detailed, and I think it took care of my other question about which activities were clearly in the realm of the MA work and where's the lack of clarity. And I think we're good with how you answered that, unless there's another finer point you want to make in the area of lack of clarity. Okay, we will move on then. So as all firms should be mindful that there is not just a registration requirement that go along with engaging in municipal advisors activities, but individuals also need to be properly qualified. Like, while firms duly registered as BD and MA, BDMA should be mindful of triggering professional qualification requirements under MSRB Rule G3. So for BDMAs, there's even a finer line that may have to be walked to ensure that there is no triggering of unregistered MA activity by engaging with members of the underwriting desk. So Blake, I'll turn to you here. You're at a duly registered firm. What are your thoughts in this area? How do you keep your business lines apart and ensure that the MA registration is not getting triggered from certain activities regarding issuance of municipal securities by the MA side of business?
Sure. So when we're MA, we have a banking unit that sits on the private side of our house, and then our capital markets unit sits on the public side. And our underwriting team sits in the middle. We call them fence sitters, and they govern the flow of information between the public and the private side of our business units. And so we have thought about this a lot over time, and not everybody manages the underwriting communication the way that we do. But when we looked at the process of pricing a transaction, we felt like it was useful to include underwriters in that discussion, given that they have direct market access and are watching the flow of deals over time, both in real time and then over the course of time. And they have experience on actually pricing deals and speaking with customers. And so they're in a better position to communicate with the underwriter when we're the MA at, insert firm name, and have a thoughtful discussion about the underwriting process. And so in going through that analysis, we felt like it was most appropriate to register our underwriters as municipal advisors. And so basically, we have a number of underwriters at our firm. At this point, all of them are duly registered. Not all of them have always been duly registered. But the ones that are participating in the pricing discussions on municipal advisory transactions are all registered as Series 50 municipal advisors.
Thank you, Blake. So let's keep moving. We're going to talk about another area, which is a common source of confusion, which is participating in investment-related activities with municipal clients. So under the MSRB definitional rule D9, issuer is deemed to be a customer. Rule D9 notes that except as otherwise specifically provided by rule of the board, the term customer shall mean any person other than a broker, dealer, or municipal securities dealer acting in the capacity as such or an issuer in transactions involving the sale by the issuer of new issue of its securities. That was a mouthful, but that's the definition. A question always comes up surrounding issuer's client brokerage account having bond proceeds, and we know that the commission has noted that proceeds of municipal securities for purposes of the term investment strategies is consistent with federal tax laws and regulation related to the definition of proceeds. So the mere fact that the proceeds are commingled with other funds generally does not cause such monies to lose their character as proceeds in an issuer's client brokerage account. FINRA Reg Notice 1928 has attempted to address issues of dealer triggering MA registration and provided guidance in this area around procedures and controls. Phil, I would really like to turn to you to walk through some important focus areas mentioned in that notice, including consideration that you think member firms should have top of mind when they're evaluating the source of funds.
Okay, thank you. There are a couple areas here I'd like to kind of focus on. One is I see firms failing to establish a process to review new and existing municipal client accounts and the source of funds that are deposited into those accounts. Two, I see firms failing to provide clear and timely disclosures or disclaimers to clients, such as disclosures evidencing an intention to act as a municipal underwriter rather than as a municipal advisor as required under G12. And I'd like to share a little fact pattern here that I've recently run into. I am examining a BDMA right now, and they have been acquired by a commercial bank. And the BDMA sent some letters around to their municipal advisor accounts explaining to them that they have sold their stock to the acquiring bank and that the municipal advisor engagement was not going to change much. The firm, the BDMA firm, was still going to handle their business. But there was a clause in this agreement that said, upon closing, the agreement will be deemed to be assigned under federal law due to a change in ownership. So I went back to the firm and I asked the question, well, are you assigning this contract to the commercial bank? Meaning, when I say contract, the municipal advisor agreements? Because if you are, the commercial bank is not registered with the SEC or the MSRB. And so how are you signing a municipal advisor contract to somebody that's not registered? And so the firm thought a little bit and then came back and said, well, we didn't really mean for that letter to say that. We were just giving a disclosure to our municipal advisor clients that we were being acquired and that the relationship was not going to be changed. Well, then that precipitated, did you make your G42 disclosures? Or did you go through the process of analyzing any potential conflicts or anything like that? And I'm still waiting to hear back from the firm on that. So I think the kind of the long and the short of, if you're going to make disclosures or disclaimers, please say what you mean, because it then can become very confusing and you may create other issues that were not intended.
But would you say that takes care of like the common pitfalls that you're seeing in this area or anything else to add?
The firm's written supervisory procedures and supervisory systems should include a review and assessment of the firm's business activities with municipal entity accounts. This includes like establishing a process to review new and existing municipal accounts and the source of funds that are deposited in those accounts. Firms can handle this in many different ways, right? But I think the best process that I've seen is when the new account forms are set up. It's very easy to include in those forms, did you get a no bond proceeds letter? Do you have a negative consent letter? Was there an IRMA letter available? Those are real easy check the box items that can occur in opening a new account and that can help you solve a lot of your problems down the road.
Thanks, Phil. And we'll talk more about IRMA a little bit later. Blake, did you want to add anything from your perspective of a duly registered firm?
Sure. So when you're speaking of the investment of bond proceeds, I think and dealing with municipal accounts in general, I think it's important that each firm go through an analysis and, come up with, who is your customer, what is your role, and then who are you going to let essentially touch these accounts, because it's very easy to trip one of these wires accidentally if you don't have sensitivity to it. So, underwriting bankers know how to perfect the IRMA exemption. They've been doing that since the MA rule went live. But in muni sales, depending upon where you are and how many times you've dealt with, Phil or someone else on his team during an exam, you don't really understand, the pitfalls. And so, yeah, I can perfect the IRMA exemption, but if the IRMA on the other side isn't involved in the discussions that you're having with the client, then all you have is a piece of paper. You're not actually protected if they're not giving advice on the investment of bond proceeds. Not all firms do. Some do, some don't. And then on top of that, you also need to know who the actual people are that are the IRMAs, because there's independence scenarios that you need to walk through at the individual and the firm level. And so, you need to understand, basically day by day, what's my client base and, how do I engage with them? Because in our experience, the majority of municipalities are very reticent to sign no proceeds letters because things change over time. And so you can't just, create the relationship and then never, reassess the situation. When you're creating your procedures, you'll want some, regular and rigorous program where you're making sure that the information that you have is still valid. Are you if you're on an approved dealer list, do you want to get a copy of the list of dealers that are on the list? Do you want verification from the customer that they go out to every dealer every time? There are ways to navigate this where you don't have to become the MA, but you need to understand how to do it and then document how you engage with each client. And that's the most important part of this, is understanding the relationships and how these rules work. Because again, if you have your client list and the type of exemption that you're using or the type of account that you have, and you can't walk through that math, then you're going to be exposed to follow-up questions if you don't demonstrate a clear understanding of how the exemptions work.
Thanks, Blake. I think, Mary, this is a good time if we can just take a step back and hear from you about the IRMA exemption, if you want to give a brief overview of that.
Okay, the IRMA exemption stands for Independent Registered Municipal Advisor exemption. And the final rule exempts any person engaging in municipal advisory activities in a circumstance in which a municipal entity or obligated person is otherwise represented by an IRMA with respect, and this is important, to the same aspects of a municipal financial product or an issuance of municipal securities, provided that first prong here, an independent registered municipal advisor is providing advice with respect to the same aspects. So if you want to give advice about something, they have to have an independent advisor that gives advice about the same type of the same topic. And also, if you want to rely on this, you can't be related, as Blake was talking about, to their IRMA, because they're supposed to be an independent advisor, not somebody say you're trying to rely on this, you can't be related, and there's a 2-year test for that that has a number of requirements that you should review. The second thing is, if you want to rely on this, you must receive from the municipal entity a representation in writing that it is represented by and will rely on the advice of the IRMA. You must provide written disclosure to the municipal entity that you're not a municipal advisor and you're not subject to a statutory fiduciary duty, and that you will give a copy of that disclosure to the individual and to the independent registered municipal advisor. And the disclosure has to be made at a time and manner reasonably designed to allow the municipal entity or obligated person to assess the material incentives and conflicts of interests. The rule does not specifically require that the IRMA be present when you talk to the municipal entity. So you can talk to them. The IRMA does not have to be present at the time of those conversations. So that's some brief overview of the exemption.
Thank you, Mary. Phil, why don't we turn to you? Curious, what are some concerns top of mind regarding dealers' reliance on written representation by the municipal entity? I'm curious, does FINRA expect dealers to confirm that the municipal advisor advising the municipal entity is appropriately registered with the SEC and the MSRB, and that the associate person of a dealer is appropriately qualified? To what extent is the dealer doing work in this area, and what does FINRA look at?
Okay, so let me try to break that down a little bit. Let me focus on, the dealer's reliance on written representations. And this is probably going to sound very similar to what Mary just discussed. But FINRA's got regulatory notice 1928, which in essence kind of covers, a member firm may be able to rely on an exemption from municipal advisor registration if the municipal client has retained an independent registered municipal advisor, the IRMA, and the member firm and IRMA are providing advice to the municipal client on the same aspects of the municipal financial product or the same issuance of municipal securities. All right, the member firm must fulfill the exemption requirements detailed in SEC guidance. And we're talking about the FAQs 3.1. All right, which says the IRMA must be a person registered as a municipal advisor who is not currently or within the past 2 years associated with the member firm. So where we see issues in this will be where a former municipal advisor of that firm will leave the firm and does not wait that 2-year period. So we do see situations where we run into a violation of the 2-year conflict. I mean, the 2-year waiting period. Additionally, the member firm must receive a written representation from the municipal client on an obligated person of the client that they are represented by and will rely on the advice of the IRMA. The member firm must have a reasonable basis for relying on the written representation. For example, many firms will check the websites, right? A lot of the, municipal entities will have their IRMA listed on the website where dealers can pull it down, review the scope, and to make sure they're within the boundaries of what the IRMA says. In addition, regulatory notice 1928 states that the importance, among other things, is keeping documentation that evidences a firm's rationale for relying on the exemption. So we've talked a lot, right, in a lot of panels today, document everything and the rationale behind it. It'll save you a lot of grief in the long run. And then finally, the member firm must also provide the municipal client with written disclosures stating the member firm is not an MA and not subject to the fiduciary duties the Exchange Act imposes on MAs. The member firm must send a copy of these written disclosures to the IRMA and send the disclosure at a time that affords the municipal entity an opportunity to assess material incentives and conflicts of interest. All right, so what we're trying to avoid there is making these disclosures last minute so the municipal entity does not have time to really review anything. So we just need to be aware of that. However, if a member firm provides advice outside the scope of advisory services furnished by the IRMA, the exemption does not apply. All right, I think, let's see, the second part of the question deals with, let's see, does FINRA expect dealers to confirm that the municipal advisor advising the municipal entity is appropriately registered with the SEC and the MSRB, and that the associated persons of a dealer is approximately qualified? All right. As to whether a dealer is expected to confirm that an associated person of a dealer is appropriately qualified, FINRA requires its member firms to ensure its own associated persons are properly qualified, but that requirement does not extend to the associated persons of other member firms. I am not aware that a firm is supposed to check up on the qualification of other firms' associated persons.
Thanks for clarifying that, Phil. Before we leave IRMA, I do want to pose one more question here. Blake, this one's for you. As we know, most derivatives advisors are commodity trading advisors that are exempt from the MA definition. However, the IRMA exception here only works if the issuer's advisor is a registered MA. Do you see any technical issues around the use of IRMA exception for purposes of providing derivatives advice without having to register?
That's a really interesting question. And from my perspective, the devil's in the details on this. We have a CTA business that doesn't touch municipalities, and then we have a portion of it that does. And so you need to look at each engagement individually and decide, what hat you want to wear. In the swap dealer world, thinking about it from that perspective, there's QIRs and DEAs depending upon which type of entity that you're using. We in our business, we'll step in and serve that role, and we'll opt into the MA workflow when we're doing that. But we don't just do that in all cases. So you need to look at you need to decide essentially how you're going to function and whether or not you're exempt, can be exempt from the MA rule and why. It's not as simple as, okay, well, I don't want to go through the math, so I'm just going to just opt in and call myself the MA. Because in doing so, you're opting into the entire framework of being a municipal advisor and having that fiduciary duty and meeting the conflict disclosure requirements. And so you don't want to just haphazardly make that decision, but you want to understand how you function and how you're either on one side of the fence or not, or the other, I should say.
Thanks, Blake. We'll move on to the next topic. We know there are ongoing issues in this area, and the SEC, FINRA, and MSRB has been doing outreach and ongoing engagement in this area. So we're doing continuous work at regulatory outreach conferences like this one, partnering with industry conferences and other avenues to spread the word on this issue of unregistered MA activity. Our CEO, Mark Kim, issued an op-ed piece in the Bond Buyer about 3 years ago titled Unregistered Municipal Advisor, See Something, Say Something. And I know you've heard that phrase earlier too today. Mark Kim specifically called out an area of concern where there appears to be issues. For example, he noted that engineering firms would be exempt from the registration requirement when giving advice to its issuer client with respect to project feasibility studies, rate models, and funding schedules. But registration requirements would be triggered if that same engineering firm provides advice regarding municipal financial product or structure, timing, or terms of issuance. So, Mary, we did get a pre-submitted question in this area. I look to you on your thoughts on reducing the blurring of roles in consulting engagements, in engineers, lawyers, these roles crossing into the MA rules, the MA line.
Well, as we've talked about, generally, lawyers, engineers, accountants, these other exempted professionals are exempt only to the extent they are engaging in their traditional activities. So the way I would probably approach it is look at it from, are they doing municipal advisory activity? And I would start with number one, are they providing advice, any kind of advice? I mean, if it's general information, if they're providing facts, if they're, an engineer and giving some engineering estimates, that's not advice. So you're out right there. If they are providing advice, then what is the advice about? Is it municipal advisory activity? So I would again look at it from an activity standpoint. I know we put out a lot of guidance, but I know there's still questions, and this is where I'll put in my plug for our office. You can email us at munis@sec.gov or call us at 202-551-5680. We get questions. If we need to review all the guidance that's out there, we'll do that. And we can give you some informal guidance. Again, it's informal guidance. We can't bind the commission, but we try to be helpful. So if you have questions about any of this, you can call us or email us at any time. Or if there are areas where you think more guidance is needed, you can email us about that or contact, any of the commissioners or the chair or whomever.
I think everybody, you heard Mary, you have questions, you reach out to her. All right, so another area, Dave has recently spoken about unregistered MA activity at the Bond Buyer Infrastructure Conference and covered the issue of unregistered MA activity in the area of P3. Mary, we got a pre-submitted question in this area. Please expand on unregistered MA activity in public-private partnership. Was that aimed at developers? And I'm also curious if there are areas of Dave's speech that you would like to highlight at this point.
It was not aimed just at developers. It was aimed at anybody out there, accountants, P3 consultants, accounting firms, consulting arms, international financial consultants, people not traditionally working in the municipal finance area. It's also not even limited to the P3. It's charter schools, workforce housing, unregistered activity anywhere is important to us. The work that municipal advisors and brokers, dealers do is very important. You handle millions, in some cases, billions of dollars, and that's just one issue. So, and the issues are not simple. I mean, some economists say that our industry would work better if municipal offerings were more standardized. We didn't have all these different call provisions, and it was a standard product. We know that's not the case. We know that there's a lot of money involved here. It's usually other people's money. And it's a lot of money. So it's a big responsibility, and it's very important that qualified and non-conflicted people are the ones who are doing it.
Thanks, Mary. Emily, did you want to add anything since this is your area of expertise? Anything that wasn't covered?
I think just a couple points. Number one, as I mentioned before, on the P3 space in particular, I strongly believe that development finance is an area that is growing. Municipalities are looking for creative ways to fund sustainable futures. So we're going to see P3s continuing to be before us. We're going to continue to hear speeches about, ensuring municipal advisors or consultants in this space are registered to the extent they're providing advice or blurring the lines. And I think as point number two is, I'm a consultant, so I view 90% or more of my job as education. I think for those of us in the room, we're out there trying to educate, and we should continue to educate. And the only thing we can do is, go to Mary, since she just volunteered herself. But until they're willing to listen and understand their role and contribution and how they can help protect the issuers and the investors and the other side of the party, we just need to continue to educate. And beyond that, continuing to try to provide more clarity around municipal advisor activity and exactly what that scope is.
Thank you. There have been enforcement actions in this space. We have about 9-10 minutes left. I wanted to see, Mary, if not in a lot of details, would you like to talk about one or two recent cases, even briefly, so folks know what to look at?
Okay, well, I will mention very briefly 2 cases, and these are settled actions. So, we're limited in what we can say about them in any case. But on June 30, 2023, the SEC announced settled charges against Robert Beneke, doing business as Beneke Economics, for failing to register as a municipal advisor and failing to disclose material facts about his registration status. He was charged with willful violations of the registration provisions, MSRB rules A12 and G17, and he agreed to a cease and desist order barring him from association with various regulated entities, including municipal advisors. The order finds that between 2019 and 2022, he provided municipal advisory services in connection with 8 municipal bond issuances for the benefit of 3 New Jersey municipal entities. And just moving on to another case, on August 27, 2024, the commission announced settled charges against 10 Square LLC and one of its partners, Carl Gentoff, for failing to register as a municipal advisor in connection with the issuance of $79 million in aggregate amount of municipal securities for 8 Minnesota-based charter schools. The order finds that during this period, they engaged in MA activity when they provide advice to the 8 Minnesota charter schools in connection with the offerings. The advice include advice on structuring, timing, and terms, providing information on debt financing options, advising on interest rates, participating in bond pricing, and soliciting and selecting underwriters for the offerings. They were charged with registration provision violations of the Exchange Act, and without admitting or denying the findings, they agreed to be censured and agreed to a cease and desist order. 10 Square also agreed to pay a civil penalty of $50,000, disgorgement of $51,716, and prejudgment interest of about $10,000. And without admitting or denying the findings, Gentoff agreed to a cease and desist order and to pay a civil penalty of $40,000.
Thanks.
And there are a number of other cases on our website, but that's just 2. And this has been an area, unregistered activity is an area of interest to us.
Thank you. I think with a couple of minutes left, it'll be helpful to just give some practical consideration takeaways. I'll say, just as a reminder, MAs must register with the commission and the MSRB under Rule A12. MSRB's professional qualification program requires that MAs that engage in municipal advisory activity to meet the professional qualification standard under Rule G3. These exams are designed to ensure that such associated person have the specified level of competency and knowledge of the federal securities laws, rules, regulations, MSRB rules. Issuers can also play a role in this area in determining if the firm is qualified as an MA. MSRB has a list of registered MAs on its website, and good representation comes from all of us having to play by the same rules. And I'll say again, if you see something, say something.
You can also file like a tip on the SEC. You can go right, sec.gov, you can file, that we call them TCRs, tips, complaints, referrals. You can make an anonymous tip on our website. Also, if you're looking for the municipal information, you can go to sec.gov/municipal, and there's a lot of information there about municipal advisors, all the rules, monthly, everybody who's registered as of the previous month, and a lot of all of this guidance.
And you can file a complaint with the MSRB as well. We generally refer those to the SEC and FINRA, depending on the parties involved. Since we don't enforce cases, don't investigate, but we will refer over issues to the regulatory agencies. Bill?
For the firms out there that do quite a bit of municipal entity business, training is huge. A review process of what your salesmen are doing, Blake, you'll love this. When you do your reviews of chats, emails, whatever, be on the lookout for such terms as one silly cheap note offering, my favorite bond. Things like that are red flags that should cause you to review your training and to make sure it's robust enough to make sure all the salesmen are on the same page.
Emily?
Thanks. Development finance is going to pose a greater risk to all the municipalities out there. I would encourage each and every one of you, to the extent you have the opportunity, to educate those around you, your bond counsels, your issuers, others that you're seeing, about the certain fact patterns of those other phases that I mentioned today. To do so, the more that we can get the word out on those parties that need to be registered, the more helpful we can be as to getting everybody to be on that equal playing field.
Blake, anything from you?
From my perspective in this space, and the folks from my firm have heard me say this all the time, in this arena, it is critical to understand who your client is and what your role is, because that dictates the rules of engagement from there. And so the other thing that's important to remember is when you're building your program, it's I think of it as a three-pronged test. There's examination, and then there's training, and then there's experience. Until you can demonstrate that you've gone through all three of those prongs, or people on your team have gone through all three of those prongs, you need to be very careful about engaging into a new business space, because you need to understand how that unit functions and where the pitfalls are to be able to properly assess operational and market and other types of risks.
That's helpful, Blake. Mary, anything from you, except they can always come to you with questions.
They could come to my office. Yeah, we have a rotating system, but often we do, in our office discussion, we'll have a discussion about a question we got, and we'll get perspectives from a number of people, because it's very helpful to have a lot of people thinking about an issue. And one other thing I forgot to mention is we just put out, together with our enforcement, the PFVU, the Public Finance Abuse Unit, we just published an information bulletin about what charter schools should know about municipal advisor regulation that just came out on November 5th, and that is available on our website.
Thank you, Mary, Blake, Emily, and Phil. Really appreciate you guys.
We will now take a 10-minute break. Please rejoin at 2:35 Mountain Time for the next panel discussion to address duties of co-managers in a primary offering.
Good afternoon, everyone. My name is Michael Nuri, and I work in FINRA's Fixed Income Regulation Department. And I'm here to moderate the penultimate panel for today's outreach, duties of co-managers. Before we get started by introducing our esteemed panelists, I just wanted to give everyone a second to pat themselves on the back. Thank you for the attention today and the questions. Please keep the questions coming. They're very much appreciated, and I think they make for a more robust discussion. With that said, I'm going to introduce our panelists, starting on the far left with Mark Borelli, Chief Counsel of Huntington Capital Markets.
Formerly Hutchinson, Shackey, Early and Company. Raise your hands if you remember Hutchinson, Shackey. Oh, that hurts. Not too many. So we were purely muni, and then we got acquired by Huntington, and now we're full service, but still have a very strong municipal presence, and I'm still heavily involved on the muni side.
And I'll pass it right down on to Christine Reynolds, a partner at Orrick, Harrington, and Sutcliffe.
In from Portland, Oregon, and grateful to be here where I'd rather be cold than drenched.
Moving on, Ben Biles, CEO and co-founder of American Veterans Group.
Great to be here with you all today. We're a New York area-based veteran-owned broker-dealer and very active in municipal securities.
And lastly, Adam Wendell, Deputy Chief Counsel of the Office of Municipal Securities.
Deputy Director.
Oh, I'm sorry.
I don't think we've had a chief counsel for a
No, you're right. I just mixed
No
up the
worries.
two.
And allow me to repeat the same words that you've heard over and over and over again today. The views that I expressed today are made in my official capacity as Deputy Director of the Office of Municipal Securities, but do not necessarily reflect the views of the Commission, any commissioners, or any other members of the staff.
Great. And so, Ben, I'm going to start with you, and maybe it is self-evident to some here, but could you talk a little bit about the reason and the purpose of co-managers? Why does a given offering have co-managers, and really what is the value add there?
Yeah, for sure. I mean, if our firm's fortunate to be selected as a co-manager in underwriting, we think it's a large responsibility and something we don't take lightly. I think, we've seen kind of different firms kind of do different things in underwriting, but for us, it's really to, be that great teammate and help the transaction, happen as best we can, be good stewards. I think some great practices that we've seen, just keeping the lead manager honest when it comes to due diligence. Along with that, providing an independent point of view, whether it be, in pricing calls, that's always helpful. I mean, I think we've all been in situations where you kind of have, fight groupthink. And I think that's important to have a co-manager on a transaction. In addition, with sales forces, I think a lot of firms, especially our firm, has a sales force and distribution that is complementary to that of some of the larger banks. And I think that's something that issuers have really appreciated in choosing firms like ours is, yes, while we still do business with some of the larger tier one institutional investors like a BlackRock, Fidelity, we also cover, registered investment advisors that have, an assets under management size. It's just not really, it's not really worth it for the bigger banks to cover them economically purposes. So we want to make sure that those folks are still, best involved in a pricing or a transaction. In addition to that, it's but even with the tier ones as well, our sales team might have a different relationship to the tier one. A sales force at a larger firm might have 30, 40 types of accounts that might be assigned to one salesperson. For us, we might be able to call that investor on the phone and say, hey, have you heard about this this opportunity, for example. So just more than one way to make sure the story is getting across and that folks are aware of these pricings, which I think is really important in the marketplace. And so, yeah, I think it's a kind of a system of checks and balances, and really doing and having a co-manager, I think when it's done appropriately, all in all, provides, great opportunity to kind of check and keep a lead manager in performing its duties to the highest standards, almost like that competition, so to speak. And then also bringing in, best trying to market that transaction to as many different diverse investors as possible, I think is pretty important.
Mark, why don't we kick it over to you and see if you have anything else to add?
We see this from both sides, as the lead and as a co. And so one of the things that co's can add is they might have some ideas on structuring. So it's just like a different perspective. There might be some restriction in the bond documents that somebody may say, well, do we really need that? So that might initiate a discussion. Just another set of eyes on the POS and the indenture is always helpful. That's another reason. And then another thing is, the liability is spread out. So that actually can allow the lead sometimes to be more aggressive on pricing when they know that they're not taking 100% of the liability. So that can really benefit the issuer. So I think a lot of times people will question what the benefit to the issuer is, but all these things are really helpful for the issuer too.
Great. And Christine, could you provide the perspective of counsel?
Absolutely. I think echoing what both Mark and Ben have said, we would agree that, whether we're in the role of bond or disclosure counsel or underwriters counsel, bringing in co-managers on a negotiated transaction can really add a lot of value. And, selfishly as counsel, if that's going to happen, we like to see that happen at the start of the transaction early. And then we want to have clear direction to be sure that we're getting the co-managers all the documentation that they need as well, so we can get the benefit of those second sets of eyes on things. But, it is a two-way street. And so we're hoping to hear from people, comments and questions about documents. It's obviously a tricky position, not wanting to, strike the right balance, I guess, is really what everyone is trying to do in terms of weighing in with comments and questions, and whether that's directly in the midst of maybe the one conference call that all the co-managers are on some transactions I'm on, or separately with outreach. We do welcome that. Earlier is better, so that we as counsel, if we're running the documents that you're commenting on, have time to prepare and get back and, run the traps on how those documents are going to be, those comments are going to be addressed. It can really add value and be an important component to things, but there's always that ebb and flow of how you manage everybody's differing interests. And counsel sometimes plays that middle person role. And to the extent we're here to do that, we're happy to. Just a little time and conversation to do that is what we're there to help accomplish.
Yeah, and I agree that it's the earlier the better in general.
Yeah.
I think sometimes the reason co's are not brought in as early is because Ben talked about the positives of co-manager, the value they can add. I think sometimes what happens is that you have a co-manager who's trying to prove to the issuer that they made a mistake by pointing somebody else as the lead, and just kind of, being overly aggressive with their comments. So and the issuers are just sitting there going, okay, this is too much competition. Some competition is good. So that's why I think from the issuer's perspective, maybe sometimes they don't like to see co's brought in early. But if the co's can get along well with the lead, I think it's much better to have them brought in early.
Absolutely.
And when we're talking about comments and things like that from the co-managers, and I think, Mark, you brought up structuring as well, but in terms of sticking with sort of the disclosure documents, what typically are co-managers focused on? Does it run the gamut? Is there certain due diligence on certain areas of the official statement or offering document?
Well, certainly continuing disclosure is an area that people focus on. That's because firms have had some exposure on that issue, so that got everyone's attention. So the standard, it's probably useful to talk about the standard on due diligence if you're a co-manager. So it's basically that you don't have to duplicate the efforts of the lead but you have to satisfy yourselves that the lead or the senior review the information in a professional manner and have the basis for its recommendations. So for those who are interested in the minutia of where this appears, AKA lawyers, this is, the standard is set out in the Rule 15C212 proposing release, not the adopting release, in footnote 87. So then you have to look at the proposing release, and then you have to look at the adopting release, which modified some of the interpretation in the proposing release. So it's not, as far as I know, set out in any one place. But so again, that's the proposing release footnote 87. And then some firms on continuing disclosure, I think because of MCDC, really do the same due diligence as the senior,
Yes.
and then some don't. So, I mean, I don't know that it's really necessary to do it, but some have just developed a practice where they're going to do the exact same due diligence and then kind of compare notes with the senior. And again, on due diligence, as in the other areas, if you're brought in earlier, it's not such a scramble to do the due diligence.
Yeah, I completely agree with that. We certainly see firms that are doing it as if that they're the lead manager and have the overarching responsibility. And in any position I sit in at the table as underwriters counsel who might be helping to coalesce everything and get it over to the issuer, or when I'm bond or disclosure counsel to the issuer, the quickest thing you as a broker dealer underwriter can do to get yourself in a bad position with the issuer that you want to be hired by in the future is to deliver late continuing disclosure compliance comments. That is the fastest way to be stuck in their memory banks as a firm they don't want to work with anymore. And from the counsel side, trying to track all of that down and help get that all put together and navigate that with the other side, it's definitely one of those best practices to get your comments in early and do that diligence right away. We all of the counsel and the issuer around the table will appreciate that if you're going to dig in and do it as well as the senior manager.
I'm sure everyone here appreciates the pro tip there. But Adam, I don't know if you have anything that you want to touch on.
I mean, I think those are all great comments, particularly on the continuing disclosure side. But we do need to sort of think about primary disclosure as well, because if you look at Rule 15C212. Again, it applies to primary and secondary disclosure. And if you look at, the definition in there, 15C212 applies to participating underwriters. It does not, the definition in there does not distinguish in the rule itself. Obviously, we've talked a little bit about the footnote, but in the rule itself, it does not distinguish between a lead underwriter and a co-manager. So, so the obligations are essentially the same across all underwriters, at least according to the text of the rule. And one of those is to, obtain and review the official statement and reasonably determine that, and the second one is on secondary is to reasonably determine the continuing disclosure undertaking is in place. So when you get to the, obtain and review, what does that mean? Obviously, we as regulators know and understand that in a regular transaction, the lead underwriter is going to be doing most of the work on developing the official statement, on the underwriter side. Obviously there's many different parties, in developing the official statement, but you still have that obtain and review. And I think, something that Ben mentioned in his initial comments about, keeping the lead underwriter honest. I think this is, that review that, whether it's just a due diligence call or, reading the official statement, you might be able to spot something that looks funny as a co-manager that that someone who has spent more time developing the document might not see. So there is a little bit of an if you see something say something aspect to it as well. But we and then the last thing, just saying that you can in a lot of respects you can rely on the lead underwriter. Reliance always has to be reasonable. So think about again, you may not be drafting the official statement or participating in the drafting of the official statement, but before it gets distributed to investors, you are, as a co-manager, obligated to review. And, part of that review is making sure that nothing that is odd, nothing jumps out to you that at least is worthy of a question.
Yeah, absolutely. And I think just from a practical standpoint, some working groups are better than others at making sure that co-managers are in the loop at all times and are getting the documents, and they aren't just getting the last draft that's right before the diligence call. And, because frequently that is the case, that they may not see, drafts 2 through 4, that you may see draft 1 when the deal starts and everybody is on the first kickoff call together, and then you may not see a draft until the 5th. And, to internally satisfy your diligence requirements as a co-manager, it may behoove you to think about reaching out to council and asking for those interim drafts so that you have them and can raise the point. That obviously, relies on a lot of different relationships and issues, but you have to balance those relationships issues with your actual obligations under the law to undertake your tasks.
Sure, and I do think the sort of other angle of that iterative process is that if, as a co-manager, you're not as much of a participant in that day-to-day iterative process, when you are reviewing it, you have a fresh set of eyes, and you might catch things that people who, again, have spent hours upon weeks and months with this document may have internalized and not see. So that fresh set of eyes, as any of us who work with documents know, is always a good thing.
Yeah, I would just say with that, I totally see it. I mean, this is obviously a compliance-focused audience, a lot of attorneys in the room, and it definitely helps to have that second set of eyes. And anything we do, which I think is a duty of a co-manager, and then in addition to it, I think from what we're seeing, speaking to issuers regularly, is some of the more savvy issuers really see, okay, sure, you guys wish you were a lead manager, but now you're a co-manager, and they have different expectations of how we can help the team succeed, help the syndicate succeed. And the same thing on the investor side too. They see who's scrappy and who's really help marketing a transaction get things done, and kind of who's maybe a co-manager that's a little bit envious they weren't a lead manager and they're just kind of asleep on the transaction, so to speak. So I think really that engagement is what's best for the marketplace.
And it sounds, Adam, not to put words in your mouth, but it's sort of the standard we learned earlier this morning, what was it, the TSA standard? So something similar to that. Just kind of shifting gears, neither of us, we're both regulators, but neither of us work at the MSRB, so please take everything with a grain of salt. And there are plenty of experts at the MSRB around for the next 2 days, but we did want to touch on the application of MSRB Rule G17 and how it comes into play with co-managers in the sense, because it does apply to issuers along with investors. And so, Adam, I'm going to ask for you to start on that if you don't mind.
Sure, absolutely. And as Mike said, I'm not at the MSRB, so if I say something that anyone at the MSRB thinks is incorrect, please jump up and wave your arms or something like that, or smack me upside the head, whatever needs to be done. The rule G17 itself is actually very, very simple, right? In the context of its municipal securities or municipal advisory activities, each broker-dealer, municipal securities dealer, and municipal advisor shall deal fairly with all persons and shall not engage with any deceptive, dishonest, or unfair practice, period. End of the rule. As anyone who's worked with this rule knows, that's not the end of the rule, because there, at least in an underwriting context, because there is a fairly lengthy guidance document that the MSRB has put out, and it actually went through the regular rulemaking process, so it was approved by the SEC as well. The most recent update being in 2019, and so if you look in that guidance talks about things that underwriters need to do in order to essentially comply with their fair dealing obligation. And a lot of those are disclosures that need to be provided. And there is a division there between disclosures that can be provided by the senior manager on behalf of the entire syndicate, and then disclosures that must be provided by each underwriter, including co-managers in the syndicate. So I think So, for example, disclosures concerning the underwriter's role in compensation are listed in that guidance as being provided by the lead underwriter. But conflicts of interest, for example, each underwriter, including co-managers, has to provide that separately to the issuer client. So that's basic overview of G17 and how it may apply to co-managers.
And I'll just reiterate again, the MSRB has a great website. If you go to the Rule G17 and then click on interpretive guidance, the, forgive me, is it notice, or the 2019 publication
Yeah.
is available, and it talks about the dealer-specific disclosures that you just referenced. Mark, I want to look over to you kind of from your experience from the industry side.
There was a very well-intentioned aspect of the interpretation, which was to cut down on the disclosures by having as you said, having the senior provide some of the disclosures and having the co's just provide the disclosures specific to them. In practice, that hasn't really cut down at all on disclosures. So it's something that maybe it can be looked at next time it's amended. Because in practice, what happens is underwriters, we started out having two different forms. So we had a form for when we're senior and a form for when we're a co. That was the idea. And then at some point, my public finance people came to me because I helped develop the forms and said, nobody else is doing this. Everyone's just using one form. So now what happens most of the time, almost all the time, is that every underwriter says one letter and they just send it. So the issuer is they're still getting the same number. They're just getting more pages and it's all email. So you could argue it's not a big deal, but in practice, it hasn't really cut down on the volume because people are so risk averse. They just, and sometimes you don't know if the seniors provided it. So that's another reason the codes are just like, all right, we're going to give our own letter and it's just one more email. And I think the issuers are used to it. So that's kind of the reality of how that's played out.
I'm seeing some nods from Christine and Ben. I don't know if either of you had anything to add or not, but.
No, I agree with his comments.
I agree, and I don't think the issuers know. I mean, I as I see them come through when I'm often copied on them, it's the banking firm sending them to the issuer and the MA, sometimes copying in counsel of one side or the other. So no other underwriter on the syndicate is going to know that those emails have come through. And to your point also, Mark, about the issuers, being used to it, I think that that's very true. And I honestly think that's, they're really not reading them and necessarily appreciating, where there is disclosure about conflicts of interest, how those might then flow through into what maybe needs to be some, third-party disclosures in the offering document about different roles some firms may have as underwriter and credit facility provider and arbitrage, all these different ways that you can have different, overlapping roles that don't really have a conflict of interest, but do have relationships among the parties that end up needing to be described. And I don't necessarily think issuers are really paying attention to that. They're just received, acknowledged, move on.
I guess this is one, it's a rhetorical question, but I'm just curious, the purpose of the distribution list with everyone's emails, you would think that there would be more consistency in who receives the disclosures. But as we talk about some of the applicable rules and regulations, another one that comes into play is the primary offering practices MSRB Rule G11, which, applies to both sole or senior syndicate managers, but also has aspects that apply to co-managers. Adam, I'm going to look to you again to assist with sort of just giving a high level understanding, and we'll look over to the MSRB to make sure that we're saying everything correctly.
So, G11 is unlike G17, where the rule itself is one sentence. G11 is a pretty big rule with a lot of primary offering practices provisions in it. But I want to highlight two in particular. First being G11B, where for every dealer that's not the lead underwriter, so co-manager that submits an order to a sole underwriter, I guess in the case where it's just a selling group member, or to a member of syndicate, has to disclose at the time of submission of that order if they were being purchased for a dealer account or a related account. So that's a conflicts rule. So that's one. When you're submitting your orders to the lead, who are they for? And then more importantly, I think for for this purpose, going down to G11K, where every co-manager that submits an order during a retail order period, so it's not mandated that there be a retail order period, but if there is a retail order period, anyone submitting an order to the senior manager during that retail order period has to provide certain information, regarding the order, if it is designated as retail. Whether it's from a customer that meets the definition of retail that's set forth in, the document establishing the retail order period. Two, whether the order is conditionally committed or not. Three, whether there's been more than one order from that retail customer for the same QSIP. 4, any identifying information, and 5, the par amount of the order. But so that's G11K. Being submission of basically how you submit orders and what you have to disclose when you're a co-manager submitting retail orders to the senior manager. So I want to just take a minute here to highlight some cases. They're not brand new cases. They're a few years old. They were, colloquially known as the flipper cases. And those were cases where, in a lot of respects, co-managers were submitting retail orders on behalf of customers that were not registered broker-dealer firms. And in fact, those firms were cited for unregistered broker, being an unregistered broker-dealer, because these firms were buying the securities ostensibly as retail and then immediately selling them at a markup. So essentially, but the co-managers were cited for G11K violations because in many cases they knew or should have known that these customers were not really retail customers. So I just wanted to highlight that as an important duty of co-manager. If you're submitting a retail order, based on these cases, you need to, be reasonably certain. You need to know, or at least do enough diligence to be confident that it is a true retail order.
Yeah, it used to be if you had a customer that was just an LLC, and there was really it wasn't like an operating business. It's just an LLC. That might be a red flag. That might have been a cause of kind of looking into it more to see if they were actually a customer, or if they were, these firms were basically in the business of doing this. And the unregistered broker-dealer issue was interesting because they're basically saying that they had all these broker-dealers as their customers and that they were in the business of buying and selling securities. But as I used to tell people when I was in private practice, when you run into issues like this, there's plenty of liability to go around. So they went after the firms, and I think that was right for being unregistered broker-dealers, but then they went after the broker-dealers too, because they, in the view of the SEC, should have known that these were not really retail. So I don't know that happens too much anymore, at least, among like the more legitimate firms, but that was at the time that a lot of firms got caught up in that.
And a lot of it also, which most of the audience probably is aware of, has to do with the definition of retail, because each offering might have a different definition if they have a retail order period or some sort of retail priority, and the orders have to meet the definition, whatever that is. Ben, I wanted to check if you had anything.
Yeah, I would just say, and to echo these comments, I think co-managers really have, they are, the buck stops with them when it comes to doing, the proper due diligence on these retail orders and really looking into the retail order policies. And, is it professional retail or just retail and really staying engaged. I think that's a common theme that we're hearing here for success with co-managers. When you're an engaged part of the process, I think, it's better for the marketplace. When you're not, it's not the best for you, the firm, the marketplace. I think, just kind of trends going for that we're seeing in the business from issuers is, I think a common practice is, from investors that we might talk to that also, may be covered by kind of larger firms, the lead manager in particular, they'll say, well, I need to put my order in through the lead manager, or else, it's going to be tough for me to get allocations from the lead manager in the future. And that's kind of, a status quo, and I understand those concerns. And I think issuers are starting to see those concerns as well, because, they want, more diverse participation in the marketplace. And so what we're seeing a lot of times from some, I would say, kind of pioneering issuers is really driving the process, taking kind of more control back from maybe the lead manager in terms of allocations, and really get kind of more hands-on for being engaged in the process themselves, is kind of what a trend that I'm seeing from some of the more kind of regular issuers in the marketplace that we talk to.
Yeah, the pure retail that's sort of, it's kind of like a teenager who actually uses their phone to talk. It's kind of, pretty rare. The professional retail is, for us, much more common. So by pure retail, I mean like the individual, and that there's a broker actually calls the person and says, I recommend this bond. That we don't see as much anymore. And a lot of times the definition of retail will include professional retail, but that's like an investment advisor who has retail customers. That's still very common. But and the other thing we've seen is that the retail order period, we don't see very much anymore, but we still see retail priority. So in other words, like an entire day where it's only retail orders, I don't think that's very common anymore. But we still do see retail priority. But for that to be only pure retail, I don't think is very common anymore.
And I don't want to speak to the thing, but there is, I think, an industry distinction, as you're saying, between sort of a defined retail order period versus priority. And, that's something that I think the regulators in the industry can continue to work to make sure we are all on the same page. But just moving along, another kind of part of, the primary municipal market are, I think they may be called distribution participants at times, or third parties that have a distribution arrangement with the co-manager. And Mark, I was hoping you could maybe give sort of an explanation in what a third-party distribution agreement or arrangement would mean for.
Yeah, so so you're a co-manager on offering, and this is an arrangement with the firm that's not actually an underwriter, but it expands your distribution capabilities. Maybe they're in a particular region. Maybe they have access to some professional retail or actual retail that you don't have. You do have some added diligence where you want to make sure, because you actually are the underwriter, that their orders are proper. They're following the terms of the distribution if there's retail priority, for example. And then the other thing to remember, though, if you're a co-manager with distribution agreements, is you want to make sure that the issuer knows about those, because that's a lot of times something that's going to need to be disclosed. And the other place we see it come up is in RFP responses. So it's something, if you have those, even if you don't use them very much, a lot of times in RFP, they're going to ask you if you have distribution arrangements. So it's important to remember to disclose those, like we have one with our affiliate, for example.
And Christine, it sounds like it's important to disclose to the issuer. Do you feel the same?
Yes, and I think, if we've all seen offering documents that have in the underwriting section, a handful of paragraphs in that section that describes all the various distribution agreements that various underwriters have entered into. And I think I agree with Mark that it's important to get those. They come in sometimes, if you work on a large credit with a large syndicate of senior and co-managers, you might be working from the last offering document, and those distribution agreements may have changed, since the last deal, updating those early and frankly, updating them not just by sending them to council and having the changes show up in a red line, but really having the conversation with the issuer that's hired you as a co-manager to make sure they understand why you've changed that arrangement, and hopefully great. You've done it, made those changes because there's benefits to that, and making sure that they're aware of those and that it's not just, kind of the boilerplate part of the OS that no one's paying attention to.
Ben?
Yeah, I would just echo those. I mean, I've seen instances where a co-manager had a distribution agreement, didn't bring it, to the issuer's attention until the final hour. The issuer, allowed it, but then I think the OS had to be, minute at the final minute, which was, not ideal. And I think when a distribution agreement, works properly as it should, it's, I see a lot of benefit. It adds, more, more investors can be, marketed the opportunity, which is a good thing. However, with the points that are brought up today, you also, have added risks that if that's, if that broker dealer is giving you, those retail orders that, the risk often falls with, the co-manager firm to make sure that is in fact a retail order, and you need to do your own due diligence, et cetera. So, I think, when properly documented, when you, inform, stay engaged, and also make sure, these orders are who they say they are, I think it could be a benefit.
Adam, I don't know if you would disagree. I'm sorry.
No, I actually think that, I think everything that Ben just said in particular, it was very much on point. That, yeah, I mean, I think as regulators, I don't know that we have a position on these distribution agreements. But, again, disclosure, correct, proper communication, making sure that, that everybody, has checked all the boxes is from a regulatory perspective, and, document, disclose, and, is what's important.
And likely to the extent there are downstream communications from the senior and the third parties are not, I don't know, in the IPO wires or like there might be some information that may need to be like the definition of retail, for example, right? Let's just see. Kind of our last preset topic. Let's go to Ben. I think we wanted to just talk a little bit, not too much in the weeds, but something that I claim to have no expertise in and never necessarily wanted any expertise in, but net capital requirements for broker dealers.
Of course, happy to discuss, Michael. So I think it was said earlier, it's, historically co-managers have been used. One of the reasons in transactions is to, kind of spread the liability in a transaction, right? I mean, you would see kind of old IPOs, in the early part of the 20th century, and there might be, 50 co-managers of the deal or something. And so it was a way to kind of, pull everybody's capital and liability to help the transaction succeed. With that, with a number of different historical lessons that the industry's learned along the way, we have, the SECA rule 15C3-1, that defines more net capital requirements for broker dealers. And so, from my experience being at the helm of my firm, I very much know what net capital requirements are. I'm sure a lot of the compliance folks in the audience do, but I find that, whether it's a, younger debt manager for an issuer or, investor, et cetera, the, newer folks that are coming into our industry might not have heard of this. And so, for example, from what I've seen is talking to issuers, they might say, all right, Ben, we'd like you to just have maybe a, $20 million bond roll in our transaction, but you don't have, X amount of capital, therefore, we don't feel you can participate. And so, well, have you heard of this, this rule? And actually there's a, 7% haircut for municipal securities as defined in 15C, and it kind of, is an introductory to that. So I've often become a great educator in that role. But there's a method to the madness. I think there's reasons that we have these rules, and for us, it's very important to understand the timing of when those haircuts come into play, as well, and really to help educate the marketplace on why these exist and what it means. And so, for us, we're very open and engaged with, what our net capital, currently is, how that relates in terms to the liability we can perform in an underwriting. And, you know, it's a big part of, you know, when you're at a small firm.
And then there's also the issue of then when the charge, you can stop taking the charge. So that's kind of an issue that's come up in terms of if you know, for example, you're not going to be allocated bonds, at what point can you stop taking the charge, which is for technically for open contractual commitments. So that's an issue that's come up recently. And I think FINRA is focused on that in exams.
It's been brought up in SIFMA publications, but it is something that is being looked into, and I'll look to you, Adam. Just, you know, I think there are different angles with regard to net capital in the primary market.
Sure, and I will say this is something that I have become educated in the more recent side. But so, you know, to sort of play off what Ben was talking about, how one of the reasons for co-managers is to, you know, spread around liability. Also, though, sometimes from the issuer's perspective, one of the reasons for co-managers is to involve different firms. Sometimes those are, you know, veterans firms, minority-owned firms, women-owned firms, and, you know, a lot of times those firms are small. So, you know, and sometimes net capital can be a struggle for them. So, but there are two things that I want to highlight. Number one is that there's sometimes in a negotiated deal, is a little bit of confusion in that, because so for a for registered securities, you know, most corporate securities and things like that, the net capital rules do not allow you to use a bona fide pre-sale to offset your net capital charge. In a municipal securities deal, which is not registered, in many circumstances you can do that. So if you've got customers on board, obviously it has to be documented properly, but you may be able to use that to offset your net capital charge and help you out a little, give yourself a little relief. So some that in itself is something that sometimes is a source of confusion, particularly for people that don't just do munis. And then the second part is what a lot of times we hear that issuers will prefer negotiated sales over competitive sales because it's easier for them to bring in these smaller firm co-managers, which often have trouble participating in competitive sales because they cannot offset, or they believe that they cannot offset their net capital charge with the bona fide pre-sale. So, and the reason for that is because in a competitive deal, the underwriter doesn't know whether they're getting the deal. So how can they actually have a firm pre-sale underneath it with their customer, because everything is conditional. So those are issues that we've heard and that we've been discussing, with the other regulators here. That those conversations are ongoing, but those are sort of the concerns that we've heard, and we are aware of them, and those conversations, like I said, continue to happen.
All right, we got a couple questions in. Let me just read out the first one. Sorry, I can't walk and chew gum, but as we were discussing the co-manager role, someone asked if we could direct them to guidance on how the lead role differs and what is expected if a dealer were to take on that role. I think there is a lot, to a certain extent, a significant difference, and we could spend a whole panel talking about that alone. But I think, Adam, you referenced MSRB Rule G11 and some of the different disclosures in G17. I mean, I'll look to the rest of the panel, but I think there's not like a quick answer, at least that I can think of.
I mean, what the most, I guess, explicit example of that is probably the G17 guidance that I was talking about before, which does in fact list, these are disclosures that can be given only by the lead underwriter, and these are disclosure that have to be given by all underwriters. I mean, in terms of what is the difference in that place, at least it is explicit. I don't know if anyone else has any.
Yeah, I don't know if I've seen a guide in terms of like the overall responsibilities. I'm not aware of anything because it's, the lead, I mean, it's so different in terms of you're the first one in there. I mean, you're basically structuring it with input. And in terms of the order period and kind of working all that out with the issuer. I mean, it is very different, but I'm not aware of like any guidance that I've seen on that.
I mean, I would just say again, the MSRB website is a very useful resource and has a lot of publication literature that talks about a lot of this and on top of their rules and the guidance related to it. Just moving to the next question, and this is kind of interesting. Someone asked, what is the municipal advisor's role or responsibility, if any, during the bond underwriting order period or allocation of orders? I don't think, is anyone we're focused on the broker-dealer aspect, but perhaps if anyone wanted to talk about their experience with the involvement of, I don't know if the municipal advisor has like game day access, if that's what it's called in IPRIO, or some of the other checking the order book, but kind of just look to the panel to see if there's any comment that they had.
We're an MA also. I don't know how much detail there is in terms of the actual orders and viewing the orders, but certainly they would get that information from the underwriters and have some input into pricing. But as far as like full transparency on orders, I'm not sure that they would have that or need that, but they would get information on orders from the underwriter, and that would allow them to have input on pricing. And then, as we were talking about in one of the other panels, this came up because you may be an MA, you may also be a broker dealer. You may go to your desk to get input. And the reason that came up earlier was there was a question about whether those people also have to be registered MAs. So that it's more just getting feedback from the underwriters and having input on pricing.
Right, and I'll just echo, we can always, there's the MSRB website. I think the scope of services and the roles that the MAs will take on in different transactions can sort of dictate what they may be doing in that regard. And I'm sure that there's a lot of practices.
Yeah, I mean, as we've seen, the MA will certainly, or almost certainly, have some role in pricing, but as far as as far as individual orders, I'm not sure exactly how that works in practice.
With that, I don't see any other questions. I'll just pause if the audience has anything. Otherwise, just want to say thank you for the time again. Have a great rest of your day.
Thank you. Thank you.
Thank you. We're now on break until 3:45, and we'll resume with our last panel of the day on exam and enforcement matters. Thank you.
Good afternoon, everyone, or good evening to those joining us virtually on the East Coast. Thank you for joining the last panel of the day, which is panel 5, Regulatory Outlook, Examinations, and Enforcement Priorities. My name is Frank Mazzarelli. I work as a director at the MSRB. We have an outstanding and highly experienced panel for you today. And if you joined us last year for the Regulatory Outlook panel, you'll recognize some familiar faces. We have Gene Davis and Megan Ferguson from FINRA, and Tina Barry and Rebecca Olson from the SEC. The way we're going to structure the discussion today is to start with exams, and then the second half we're going to switch over to enforcement. And we will try to reserve some time for questions at the end. Gene Davis is going to start us off by giving an overview of FINRA's exam areas of risk focus, common exam findings, and even some helpful hints for firms undergoing an examination. So take it away, Gene.
Yeah, thanks, Frank. So I'll start going through our priorities, areas of risk that we're looking at in 2025, some common findings to help give you the landscape that FINRA has incorporated into our exam plan. So first and foremost, I'll start with our dealer priorities or our dealer areas of focus, and then we'll get into maybe some more specific lines of business, public finance, trading, execution, whatnot. But from just traditional dealer business, an area of focus, obviously at the top of our list is Reg BI. That's where the rubber meets the road with customers. And so obviously it's probably going to be at the top of our list for 25 and years to come. So what are we looking at for Reg BI? The way I have it in my head, we're looking at it from two prongs. The level of activity. So the actual level of activity that we're seeing in customer accounts, does that meet the financial status, the risk tolerance, investment objectives of the customer? So when we talk about activity and velocity in the account, generally when we talk about fixed income instruments, right, it's an instrument to go into a customer account. It's placed into a customer account to generate cash flows, to to meet some sort of I'll say debt service, cash flows that the customer may have. It may be to offset risk from other asset classes, equities, commodities, what have you. So that being said, when we see the municipal bonds and the level of activity in customer accounts, again, we're looking at, does the level of activity meet the investment objectives, risk tolerance of the of the customer? So the other aspect that we're looking at is the individual security, right? So does the individual security meet the investment objectives, risk tolerance of that customer? So the things that the individual security that we're looking at, right? Things that you're probably looking at as well. The credit quality of the issuer, where does that fit on the credit risk spectrum? Duration risk, so interest rate risk of the underlying security. Again, can those risks or are those risks in the best interest of that customer? And where that customer is in their, I'll say, in their life, in their financial planning, it's gonna be different. And so it's up to you as a firm, as a financial advisor, registered rep, to understand those investment objectives, risk tolerance. What is the customer attempting to do with their portfolio, with their savings? And again, the level of activity, the security, does it meet the best interest of the customer? Now, a lot of times when we talk about, or at least when I talk about this, it's like, Gene, with our registered reps, we're all good. We would never recommend a security that is not in the best interest. The level of activity that occurs in the customer account, of course, it's always in the customer's best interest. And then we go to firms, we see activity, we see securities perhaps that may not meet, or I shouldn't say may not meet, but just causes to question, right? So we're looking at the level of activity. Nothing changed, say, in the securities recommended, the bonds being recommended. So the credit quality didn't change for the security. The liquidity needs of the customer didn't change, but yet we may see, again, this activity. So we'll ask what's going on, what's the deal? So don't be surprised if we come into your firm and ask those questions. Again, something that we're focused on. Moving on from, I'll say, non-traditional municipal bonds, non-traditional municipal securities in the area of 529 plans. This is an area just to kind of set, maybe set the table a little bit, but the last statistics I saw as of year end, there was approximately 450 billion on deposit in 529 plans. The average account balance was just a tad under $30,000. But when we come in and we're looking at 529 plans, again, this is a retail product. And so some of the things that we're going to ask about 529 plans are in the area of share class, A, B, C share. Was the share class that was recommended to the customer, was that in their best interest? And before you can recommend a share class to a customer, you have to understand the customer's intended use of the funds, right? Are they going to use it for K through 12? Is it going to be held for a short time? Is it going to be held for a long period? So you have to understand those instances of the customer or those characteristics of the customer before you can recommend the share class, much less, okay, a portfolio. Is it going to be, a growth allocation or fixed income allocation? Couple of other areas that we're looking at in 529 plans that straddle between Reg BI, straddle between disclosure, are out of state recommendations and K through 12 qualified expenses. So again, what you need to know is, okay, where's the customer located? And if you are recommending a 529 plan that is not in that customer's state, that perhaps may offer some tax advantages, what's the reason there? As well as that there's some disclosure obligations according to, pursuant to G47, some time of trade disclosures. So there's a disclosure obligation as well as a Reg BI obligation, or that we may ask about when we see out-of-state plans. K through 12 expenses. This is a relatively new feature of 529 plans, but now 529 plans can be used not only for college. We still like to say 529 college savings plans, but in fact now they can be used for educational expenses K through 12. So if you're recommending those plans that are going to be used through K through 12, again, you have to understand how is the customer's intended use. For K through 12, that's going to be a much shorter duration, as well as some potential time of trade disclosures. If the customer is using those funds for K through 12, there are currently, probably get this wrong, there are states less than 10, I believe, that don't currently recognize that exemption. So if a customer intends to use use 529 plan funds through K through 12 expenses in one of those roughly 10 states, you need to make a disclosure, and then obviously we'll be like, well, what's the reason for the recommendation? So moving on the opposite end of the spectrum. So we talked about some Reg BI plans, very retail focused product in 529 plans. Another area that we're looking at is, we have been, is in the aspect of muni shorts. And forgive me, we have, it's kind of, I'll say jargon, but muni shorts, that's a term that we use to describe activity where generally it occurs in one of two instances, but a firm may have 50 bonds in inventory and then may sell 50 to customer A, 50 to customer B at relatively the same time. And so we've oversold. Our inventory in the firm is short 50 bonds. A similar instance where we see is you may buy from the street, buy 50 bonds, and then simultaneously sell to a customer. And as time goes by, the days tick on, the street side trade hasn't delivered those bonds to us. So the the counterparty is we're failing to receive those bonds. In each of those instances, we have some consequences that potentially occur. In the municipal world, right, it's potentially if it's a tax exempt bond, the customer that purchases that security is expecting tax exempt interest. Well, if you or the clearing broker doesn't maintain possession and control of those securities and then starts receiving the interest payments through DTC from the issuer, then what the clearing firm sometimes does is create substitute interest and pay interest essentially from their own pockets to the customers. So the customer, it may say on their account statement, I own 50 bonds of, such and such municipality. However, when we look at the stock record, the actual location, those bonds, they don't really exist, or the firm doesn't have them. And so there's some consequences there. Again, if it's substitute interest if substitute interest does apply, then are you making disclosures to that customer that, hey, what you're getting is not in fact tax exempt interest, it's taxable interest. The 3.3, so possession and control, firms have to take steps to reduce securities to possession and control. And so if the firm doesn't take reasonable steps to reduce those securities to possession and control, then that's an issue there. And when we're at firms and, we're focusing on the areas, we're not looking for like kind of the one-off or, an outlier here or there. When we've gone to firms and it's really been problematic, we've seen those fails that are years old. It's 3 years old and the firm is not taking steps, what we would consider reasonable steps to reduce those securities to possession and control. So that's in the traditional dealer space. Moving on to more of the trading and execution area, what we're focusing on, markup, markdown, confirm disclosure. I can't believe it's been 6 years now since markup, markdown, confirmation disclosure has been effective. But what we have seen when we're at firms, it's really been, I'll say, two categories. Those firms that use a manual system. In each of the two categories, there are different risk characteristics that come along with that. So the first one is the firms that use manual entry. So going in and an individual manually putting in a PMP, or the prevailing market price, so that the markup, markdown disclosure can be put onto the confirmation. The other prong are those firms that use firm systems. So there's some system in the background that is using logic and making calculations to determine the PMP, determine the waterfall, so it can be disclosed onto the confirmation. Again, each one of those have their different risk characteristics. On the manual side, right, it's kind of like no surprise when you have a manual system, the risk that you run, someone forgets to do it. Someone's out, you have some new hire, they don't fully understand how to implement it. Things get busy, they forget to input it. They look at the wrong PMP, they follow the wrong waterfall to determine the prevailing market price. On the opposite end of the spectrum, the systemic, those firms that use systems to determine PMP, you don't have the risk that a manual system may have, but what you have are these other system risks, and things can change underlying in the systems, even in technology, individuals in compliance or trading, not being fully aware. So each of those areas have the risk. A best practice that we have seen has been those firms, no matter which system that you use, that some sort of reasonable sampling is taking place across the different asset classes and across different account types, across different methods of execution. So we're looking at inter-dealer trades, we're looking at customer crosses, making sure that you have kind of the full spectrum of the way that your firm executes trades, that those are included in a sample. Because if you're just relying on the systemic, on a system, things can go awry. And if you don't check on it for 6 months, things can add up quickly, as far as the number of confirms or PMP that may be inaccurate. Just sticking with the markup markdown area, right? We're the fairness of markup markdowns. So we're always looking at the fairness. Is that markup, is that markdown fair to the customer? One of the metrics that we do look at is the effect of the markup on the yield. And, I'll just throw numbers out there, but say we're looking at the inter-dealer or the wholesale market, the yield may be 5%. After it gets marked up, the customer, the yield is down to 1%. And so we're looking at the effect of that markup on the yield. Is it fair? It may absolutely be fair, but those are some of the metrics and areas that we focus on. To round out the trading and execution, I'll kind of go down the rabbit hole or get real technical here. But in the list offering price indicator, the also called, maybe known as the MO20 indicator, that's an indicator that that is placed on transactions when they're reported pursuant to G14, that it was part of the primary offering. So if you've ever pulled up Emma or Bloomberg and you've looked at transactions, and you'll see maybe it's a when issued on Emma or LOP. I forget how it's displayed on Emma, but there's an indication so that market participants, for transparency reasons, it can be distinguished. Was that transaction a part of the primary distribution of securities, or was it a part of the secondary market? Because you can have both types of transactions on the first day of trading. And so for transparency purposes, including that indicator, so when it's disseminated to the public and to other market participants for transparency purposes, those other market participants can make a distinguish, okay, that's part of the primary issuance, or was it part of the secondary market there? So just moving on into the public finance space, start with the underwriting aspect, and then we'll kind of migrate into the advisory space. In the underwriter space, what we're looking at is G32 data integrity and timeliness. So if you're not familiar with G32 and the requirements, G32, one of the requirements pursuant to G32 are that lead underwriters make certain submissions of data to the MSRB, and they're accurate, they're timely. And then another aspect are that disclosure documents are made as well. So those are going to be things like the OS, the POS, that those documents are being uploaded. FINRA has had a report card for quite some time that has focused on the timeliness of OS submissions. What we have not had a report card focused on was the timeliness of data submissions. And so some firms have conflated the two, and us, as regulators had assumed, okay, well, if OSs were submitted timely, then data submissions were also being made timely. That was an incorrect assumption on our part when we began to look at the data submissions. So data submissions, the timeliness, that's an area that we're looking at, and those data submissions are accurate. So the the accuracy, some of the areas that we're looking at that lead underwriters have to make are the identity of the municipal advisor, the advisor or advisors, the identity of the syndicate members. And some of that can be a manual process as well. And we understand, that in a firm's process in accumulating that data and making those submissions, there may be, each firm does it slightly different, but we do know that there's some manual processes in those submissions. I will say, so kind of talking about the report card, FINRA does have that report card for timely OS submissions. We do have on our roadmap, I am proud to say, we do have on our roadmap a report card that will help identify where the data is not being timely submitted. So it's in development now. Can't promise when it's gonna be available, but rest assured, it is in development. It is on our roadmap. Sticking with underwriters, underwriter pricing. We heard a couple of panels this morning talking about underwriter pricing. So what we're looking at firms when we are looking at the underwriting aspects, hey, how did you come up with the price? What are your policies, procedures, controls for ensuring that it's a fair, it's a reasonable price? Some of the things that we may ask you that we look at, there may be issues or maturities that are oversubscribed. We may ask, hey, what firm, how did you contemplate any price changes looking at oversubscriptions, or even perhaps I'll say, undersubscriptions. Any thoughts about price? What we have seen there, really, firms are doing things. They have a process. It's just not maybe memorialized in a written format or as robust, where a principal is taking a look at the pricing. Finally, in the underwriter side, what we're looking at is also, I'll round up the underwriter, primary offering practices, right? Previous group talked about that. And when we're talking about primary offering practices, those are going to be instances where we're looking at the orders. So the orders that are coming in, particularly focus on those orders that have retail priority, right? If a firm is marking those or the orders that are coming into the book are retail, are those in fact retail? We've seen some instances where orders are being marked as retail, being put into the book, even zip codes are in there, and we've done some digging and the orders are in fact coming from stock. So that's an area that we're focused on. I think Megan may talk about that a little later on. Kind of moving to the other prong of public finance, municipal advisory. So, right, what we're looking at there, conflict disclosures. We see the conflict disclosures fairly, reasonable at firms. Probably the biggest hiccup or misstep that we see are accompanying mitigation statements in those conflict disclosures. So conflicts will be disclosed, but not a correlating mitigation statement. A lot of times I get firms assume, well, I disclosed it. That is how we're mitigating. But it requires a mitigation statement as well in the conflict disclosures. The boilerplate conflict disclosures, not unlike what we see in the underwriter space with G17 letters, very boilerplate. What does give us, a warm fuzzy feeling where you can see the firm actually went through and had a framework to determine if there were conflicts. You see differences in the conflicts, in the conflict letters that are being provided to issuers. It's not just the compensation, conflict, which is I'll say easy, and hopefully everyone's getting that right. Evergreen agreements, someone talked about that, I think this morning, to a little, maybe a small extent. Evergreen agreements are those agreements which it may be 10 years old, but we executed this agreement in, 2015. It's still in effect today, but look, things change, conflicts change, mitigation changes, compensation changes. So does the firm have a framework in place to update those agreements as they get older? So we are seeing issues there. And then, so unregistered municipal advisory activity, I don't know if we're getting smarter or the game is slowing down for us a little bit, but we have filed tips with the SEC probably in the past year where we're at firms, we're looking at underwritings, and we see participants in the underwriting doing some things that cause us to question. Now, when we pass it off to the SEC, we don't know what they do with it. But we do make those tips to the, we have been making those tips, it seems like more frequently in the past year or so. If I have a couple of minutes, Frank, I'll just give some quick tips for dealing with an exam team, and developing procedures. So if an exam team shows up, starts issuing requests, for production, early and frequent communication with the exam team is paramount. A lot of times exam teams will issue requests for documents and things and assume that the document that the firm maintains a document in such a format or fashion that it's going to be easily retrievable and easy for you to get. We are not trying to cause undue stress on the firm trying to go and recreate documents or create something or pull something in such a format to satisfy examiners. If you have documents or records that may get to the heart of an exam team's review, by all means, have those conversations with your exam team. Hey, I know you've requested this. You've got 20 things where you say, give us a list of underwritings, and you've got 20 things under here. I've got this list and I've got 5. That may be fine. The exam team, hey, I can get what I need to do with those.
Hey, Gene,
with those 5 things.
On that point, would it be fair to say that you encourage questions from the firms instead of just an examiner coming in and saying, okay, we're looking for these 5 things? Would it be, helpful for firms to say, well, would you like this? Would you like that? Or how can I get you those things? Like have that conversation early and have like a back and forth. Because I know that we've heard oftentimes that, especially when things get referred to enforcement, then enforcement goes in and they start asking for the same exact things. And then they find that, firms did have what you were asking for. And if maybe the communication was just a little bit clearer in the beginning. So would you encourage firms to say, hey, ask us questions?
Oh, 100%.
Okay.
Absolutely. Hey, you ask for this document. What do you mean by this document here? Like, I know what I think this means, but what exactly are you looking for this document? You may have this other exception report that can fulfill all of the examiner's, requests. And if we had just known about, exception report 51A, does this and that, we didn't know. So anytime, you get a request, if you have a question, what do you mean by this? I know I do. We welcome those discussions for clarification, on our request.
Even emails at times, because sometimes you'll have a checklist, maybe the checklist isn't filled out, but a firm could say, you know what, though, we do have email correspondence where it shows we've been going back and forth. A principal asked, a registered rep about the exact thing you're talking about. It might not be on a checklist, but we have emails.
Absolutely.
Okay.
Oh, 100%. 100%. Yeah. Please, you're not rocking the boat. Some firms, I'm scared to, question my examiner. Do not. If you feel any hesitancy, that I cannot assure you enough. Please, raise it. We want to get in and out of your hair as quick and as efficiently as possible. Like we really do. We understand you have a business to run. And so whatever gets us to where we need to be quicker and more efficiently, we're all ears and we're game.
Great. Thank you so much, Shane. We are now going to turn it over to Tina to talk about SEC exams.
Thanks, Frank. The SEC disclaimer was provided earlier for all SEC speakers, so I'd like to note that that disclaimer applies to my comments as well. And with that, I'd like to start today by providing you with an overview of the SEC's Division of Examinations. As the name implies, we carry out the examination function of the Commission. While Gene's comments focused on FINRA's examinations of broker-dealers involved in municipal market activities, my comments today will focus on the SEC's examinations of municipal advisors. But before I get there, I'd like to share a little bit more about the division. In carrying out our examination mission, transparency is one of our guiding principles. We strive to be transparent and provide as much information as we can to the industry. One of the primary ways that we're transparent about our work is by publishing our examination priorities each year. And those examination priorities provide the industry with the areas of review that we expect to focus on in examinations during the upcoming year. We published our fiscal year 2025 examination priorities last month, and that coincides with the beginning of our fiscal year. And the examination priorities are available on the SEC website. Another way that we strive for transparency is by publishing risk alerts. Many of our risk alerts focus on common findings from exams. While we publish several risk alerts each year, I'd like to highlight two of them in particular. In November 2017, and then again in August 2022, we published risk alerts sharing observations and the most commonly cited deficiencies from our municipal advisor examinations. While we do not have the resources to examine every firm every year, we hope that we can maximize the impact of the exams that we are able to do by sharing this type of information. We believe that by being transparent and sharing information about the SEC's examination program helps to promote compliance across the industry. By providing you with the information about areas that we believe pose compliance risk, we hope to focus your attention on these areas. We hope that the staff at your firm will take a look at the areas we highlight in our publications and critically evaluate your firm's operations to determine whether any improvements are needed to achieve compliance with the securities laws. When we engage in discussions with industry members, particularly in discussions with municipal advisors, we often receive a number of questions about the SEC's examination process. So I'd like to spend a few minutes discussing how we conduct exams at the SEC. The examination process from a firm's perspective typically starts with the receipt of a phone call from an examiner announcing the start of an exam. And that's followed shortly thereafter by the transmission of a letter to the firm requesting documents and information. During our early contact with a firm, we will often hear the question, why was my firm selected for an exam? Unfortunately, we typically do not disclose to a firm why they were selected. However, what I can say is that we use a risk-based approach for selecting firms to examine and in determining the scope areas to review in each examination. A firm can firm's client base or for a review of a particular compliance area. We may also consider whether the firm has been previously examined, the scope of any prior examinations, and many other factors. The next phase of an exam involves the examiner's review and analysis of information provided by the firm. This phase of an exam also may involve interviews, either over the phone, through video conference, or on-site, and there may be multiple requests for information and interviews. The final phase of an exam involves the exit conference, and that is where examiners will verbally present their findings from the exam, and that will be followed by a closing letter, either a deficiency letter or a no further action letter. A deficiency letter summarizes the staff's findings from the exam, and requests that the firm respond within 30 days describing how the firm will address the deficiencies. A no further action letter, on the other hand, states that the exam is complete and that no further action is requested by the firm. Please note, this does not mean that all of the firm's activities have been determined to be in compliance with the federal securities laws. It just means that no further action is requested at that time. To help explain the examination process, we have a 5-page document on the SEC website called the examination brochure. And we also provide the examination brochure to firms at the start of every examination. I would also like to note the existence of the SEC's examination hotline. The examination hotline may be reached by phone or email, and the contact information is in the examination brochure. Firms may use the examination hotline to communicate comments, complaints, concerns, or questions, and the examination hotline may also be used to verify the identity of an examiner. If there's one tip that I can provide to firms undergoing an examination, it would be to encourage open lines of communication during the exam, similar to the point that Jean made. If a firm has questions at any point, really about anything, please reach out to your point of contact on the exam. If your question is not resolved, please ask to speak with the exam manager or the assistant director on the exam. You know, we at the SEC, we understand that we operate in a complex industry and that all firms are not the same. So to the extent that it's not clear what an examiner is asking for in a document request or in an interview, please feel free to ask clarifying questions so that everyone can get on the same page, especially before you devote resources to gathering, reviewing, and producing documents that ultimately might not be responsive to an examiner's request. Turning now to the SEC's examination priorities for municipal advisors. First, I'd like to give you a sense of how many exams we conduct each year. For the last few years, we've conducted between 40 and 50 examinations of municipal advisors, and in fiscal year 2025, we expect to conduct a similar number of municipal advisor exams. As we noted in the examination priorities that we published last month, we have several examination priorities for municipal advisors. Specifically, over the coming year, we will continue to examine whether municipal advisors have met their fiduciary duty and whether they have complied with MSRB Rule G42, particularly when providing advice or recommendations regarding pricing or the method of sale for an issuance of municipal securities. MSRB Rule G42 establishes the core standards of conduct and duties of municipal advisors. The rule has several components, but let me start with the duty of care. During examinations, to evaluate whether a firm has complied with its duty of care, we will focus on whether the firm had a reasonable basis for any advice provided to the client. We will ask questions such as what facts form the basis for your advice? What information did you consider? And what type of analysis did you conduct? We will also want to see any documentation that you may have to support the reasonableness of your advice. Some documentation that may be relevant to support a firm's pricing advice might be the firm's review of any recently comparable transactions, industry indices, economic conditions, the degree or nature of investor demand, and any special or unique features of the issuance. These are just some examples. There may be others. And just a reminder, there is a specific record-keeping requirement for municipal advisors to keep a copy of any document that was created by the firm that was material to making a recommendation to a client or that memorializes the basis for that recommendation. MSRB Rule G42 also requires a municipal advisor to make full and fair disclosure in writing of all material conflicts of interest. So when reviewing a firm's disclosure, we will focus on whether the disclosure is complete, meaning did the firm disclose all of its material conflicts or just some of them? We will also focus on whether the disclosure is sufficiently detailed to inform the client of the nature, implications, and potential consequences of the conflict, and whether the disclosure includes an explanation of how the municipal advisor intends to manage or mitigate the conflict. And finally, we will focus on the timeliness of the disclosure. Rule G42 provides that the disclosure must be made prior to or upon engaging in municipal advisory activities. And as a reminder, even if a firm has no material conflicts of interest, Rule G42 requires the firm to deliver a written statement to the client to that effect. Another component of MSRB Rule G42 requires municipal advisors to document each of their municipal advisory relationships in writing. As a practical matter, this requirement helps to ensure that both parties have a clear understanding about the activities to be performed by the municipal advisor. In reviewing relationship documentation, we will focus on whether the relationship documentation is dated as required by the rule, and we will also focus on when it was provided to the client. The rule requires that it be delivered to the client no later than promptly after the establishment of the relationship. We will focus on whether the documentation includes each of the 7 elements required by the rule, including the scope of the activities to be performed and any limitations on the scope of the engagement, the form and basis of any compensation, any provisions regarding termination of the relationship, and any terms regarding withdrawal from the relationship. We will focus on whether the relationship documentation is promptly amended or supplemented during the term of the relationship to reflect any material changes or additions, and whether that amended documentation is promptly delivered to the client. Later on in the panel, Rebecca will describe how one firm failed to comply with MSRB Rule G42 in her discussion of a recent SEC enforcement action. But let me move on to some other examination priorities. I would be remiss if I did not spend a few minutes talking about the forms that municipal advisors file with the Commission. And here I'm speaking about Form MA and Form MAI. These forms are not one-time filing obligations. The rules under the Exchange Act require these forms to be kept up to date with accurate and complete information. Form MA must be amended at least annually and more frequently when updates are needed to certain sections of the form. Form MAI must be amended whenever any information in the form becomes inaccurate for any reason. So during exams, we will focus on whether the information in these forms is accurate, whether it's complete, and whether the forms are being kept up to date, meaning has the firm promptly filed amended forms when required. These forms provide important disclosures to the public, including municipalities who may want to verify whether a municipal advisor is in fact registered with the Commission, or to research whether the municipal advisor has any disciplinary history that the municipality may want to be aware of. Next, let me turn to professional qualifications. MSRB Rule G3 requires municipal advisors to meet certain professional qualification requirements. And here, what I'd like to focus on is the requirement for firms to have a continuing education program. This is also not a one-time requirement. MSRB Rule G3 establishes an ongoing annual requirement for firms to evaluate their training needs, develop a written training plan, and conduct training which at a minimum must address the fiduciary obligation that municipal advisors owe to municipal entity clients. So during exams, we will want to see copies of the firm's training needs analysis and training plan, as well as records of all training programs that individuals have completed. Lastly, I'd like to highlight our examination focus on supervision. MSRB Rule G44 requires municipal advisors to establish, implement, maintain, and enforce written compliance policies and written supervisory procedures. These written policies and procedures must be reasonably designed to achieve compliance with the applicable laws, regulations, and MSRB rules. So some of the areas that we will focus on during an exam are whether the procedures describe the activities that the firm's designated principal will undertake to ensure compliance with all applicable rules and obligations of the firm. We will look at whether the procedures have been updated to reflect any new rules or rule changes, and whether the procedures are tailored to the firm's activities. And finally, we will focus on whether the firm is actually following or implementing and enforcing its procedures. The MSRB has created several compliance resources to assist firms with their written policies and procedures, including a sample template and checklist. So I would encourage firms to spend some time reviewing these compliance resources because they are very helpful.
Thank you so much, Tina. We have a question that came in. Will the Office of Examinations respect the attorney-client privilege, and will that extend to in-house counsel?
Yes, we, as a courtesy, we do respect the attorney-client privilege, and so we allow, attorneys to sit in during examination meetings and interviews.
Thank you so much. We'll now turn it to Megan Ferguson from FINRA Enforcement to talk about some recent cases.
Hello, everyone. I'm an attorney director in FINRA's Department of Enforcement, and our department has been active in 2024, issuing 18 AWC settlements that charge violations of MSRB rules. Don't worry, I know it's late in the day. I'm obviously not going to have time to go into detail on all of those settlements, but there are three main themes that I want to take time to cover this afternoon. First, and Jean touched on this earlier, violations of G15 by failing to disclose or to accurately disclose markup, markdown information on retail customer confirmations. The second theme is violations of G30 by charging unfair prices. And then third, violations of G14 by failing to report or to accurately report municipal transactions to the MSRB's RTRS system. FINRA issued multiple AWCs in each of these areas over the past year. So I'll take some time to point out the aggravating factors that cropped up under each of the themes. And I'll also note that in every one of these cases, we charge supervisory violations of G17 in addition to the underlying rule violations. And that is consistent with enforcement's continued focus on and concerns about firms that are getting things wrong, at least in part because they don't have reasonable written supervisory procedures and supervisory systems. So the first theme is G15. Around this time last year, in November of 2023, FINRA issued its first AWC charging violations of G15 since the MSRB amended the rule in 2018 to require disclosures of additional information, including the dealer's markup or markdown, as determined from the prevailing market price of the security. And of course, G15 specifically requires that a markup or markdown be expressed as both a total dollar amount and as a percentage of PMP. But as you'll see from my remarks, firms continue to sometimes miss one or the other of the categories and sometimes both. That first AWC from last year was issued to a small Tennessee firm called Home Financial. Over a 3-year period, that firm sent hundreds of confirmations to retail customers that failed to disclose markdowns in any manner. And then there were additional confirms where markup markdowns were disclosed only as a percentage of the prevailing market price, but not also as a total dollar amount as required by the rule. It was aggravating that this firm's written supervisory procedures remained silent on the new G15 requirements for 3 years after the rule was amended. During this year, FINRA issued 3 more AWCs in the G15 space, so I'll give just a few brief highlights about those. Rockefeller Financial, this AWC in January 2024 was issued to a this is a large firm. So the fine here was $100,000, which was more significant than the Home Financial fine of $50,000. And also a larger number of retail confirmations were impacted at Rockefeller. Most of the confirms failed to include any markup markdown information, but some just included the total dollar amount and not the percentage of PMP. Again, same story here. It was aggravating that the firm's WSPs were totally silent about the rule amendments for 3 years after they went into place. FNBB Capital Markets is an AWC from July that was notable because in addition to a $30,000 fine, we also imposed an undertaking for the firm to review and revise its written supervisory procedures and supervisory systems. This was a small firm, again, sent com firms that reported markup markdown as a total dollar amount, but not as a percentage of the prevailing market price. Again, I'm repeating myself, the WSPs were silent with respect to the G15 requirements. Finally, the Morgan Stanley AWC from this past August is notable for its significant fine of $400,000. That firm had a significant number of confirmations, over 19,000 confirmations that were impacted both on the municipal side as well as for corporate debt transactions. The next theme relates to G30 and fair pricing. The AWCs we issued in this space are connected by two common threads. First, they all involve supervisory violations and violations of G27 in addition to G30. And second, they all involve customer harm and restitution that we obtained for harmed customers. So of course, broadly speaking, G30 is the rule that provides that no dealer shall purchase or sell munis for its own account except at an aggregate price, including any markup or markdown that is fair and reasonable. And as a part of this analysis, a firm's calculation of its markup markdown from the prevailing market price is key. So G30's supplemental material provides information on the PMP waterfall, and there are specific types of pricing information that must be considered in a specific order as laid out in the rule. So the two AWCs that I want to highlight both involve failures by firms to properly follow that PMP waterfall. And the first is the New Edge Securities AWC from March. This mid-sized firm violated MSRB Rule G30, as well as FINRA Rule 2121, which mirrors the pricing requirements of G30 for corporate bond transactions. The firm failed to properly follow the PMP waterfall in 62 corporate bond transactions and 6 municipal bond transactions, resulting in customer harm totaling approximately $45,000. So in addition to obtaining restitution for those customers, we also imposed a $90,000 fine on that firm. The second AWC relevant here is the Jeffrey Matthews Financial Group AWC from July. This is a small New Jersey firm that also violated both G30 and the FINRA equivalent 2021. Same story here. The firm failed to correctly apply the PMP waterfall in 98 transactions, and this resulted in over $112,000 of customer harm. So in addition to restitution, this firm paid a $125,000 fine. The last theme that I want to talk about that emerged from 2024 relates to MSRB Rule G14 and RTRS trade reporting. G14 requires firms to report information about municipal transactions to the MSRB's real-time transaction reporting system. And for transactions that are impacted by special conditions that are set forth in the RTRS user's manual, firms must report those trades with the applicable special condition indicators. One example is the non-transaction based compensation indicator, which in 2016 became mandatory for trades that do not include a markup, markdown, or commission. We issued 2 AWCs this year with respect to that special indicator. In January, UBS agreed to pay a $100,000 fine for failing to use the indicator on over 90,000 trade reports between 2016, so the time that the indicator became mandatory, and 2021. It was certainly aggravating that this firm did not have any WSPs or supervisory reviews to address the NTBC indicator for over 5 years after that requirement went into place. And then similarly, in September, we issued an AWC to Pershing for failing to use the indicator on approximately 23,000 trade reports. This firm, in addition to the G14 violations on the muni side, also violated FINRA Rule 6730 on the trace reporting side by failing to use the no remuneration indicator for approximately 155,000 trace eligible securities that did not include a markup, markdown, or commission. And that indicator also went into place in 2016. And similar story to UBS, this firm for more than 5 years after these special indicators became mandatory had not engaged in any review or testing to make sure that the firm was using the NTBC and NNR indicators accurately.
Thank you, Megan. Before I turn it over to Rebecca, I had a question for you though. You seem to talk about themes with all these AWCs this year. Are there any cases that really don't fit the themes maybe you talked about? Any ones that stand out and maybe charge different violations?
Sure. Yeah. What immediately jumps to mind is actually an AWC that is hot off the press that we just issued earlier this week. It was issued to a small firm as well as 4 individuals, so 3 registered representatives and 1 municipal securities principal. The firm is Drexel Hamilton, and the violative conduct relates to that firm's participation in primary offerings of municipal bonds as a syndicate member or member of the selling group. This is actually a good piggyback off the panel that just preceded this one. Through the 3 registered representatives, the firm submitted over 500 orders on behalf of broker-dealers during retail order periods without a basis for designating the orders as retail. The reps added fictitious zip codes to the orders to make it appear that they were bona fide and qualified for the retail order period and retail priority treatment, when in fact there were no underlying retail customers. By submitting orders that violated the retail order period eligibility criteria set by the issuers, both the firm and the individuals violated G11K and G17. And the firm and the supervisor also violated G27 by failing to establish and maintain a supervisory system, including written supervisory procedures designed to reasonably ensure compliance with retail period eligibility criteria. So this involved a significant fine of $300,000 for the firm. The firm was also ordered to disgorge over $800,000 in ill-gotten gains from these trades, and in their individual capacities. The reps also received suspensions between 4 and 15 months, fines between $20,000 and $30,000, and the supervisor for his G27 violations received a 6-month suspension and a $15,000 fine.
All right, thank you very much. And that came out this week?
Yes, just yesterday.
Okay, thank you. All right, we are going to close out today's session with SEC enforcement. So the last 15 minutes, Rebecca, all yours.
Great, thank you. Just starting out, all the cases I'll refer to today are settled administrative and cease and desist proceedings where the respondent agreed to settle the charges without admitting or denying the SEC's findings. I am not going to cover any off-channel communication cases. I think those were more than covered in panel 2 earlier today. I have 3 broker-dealer cases I want to mention and 1 municipal advisor case. And I'll say, continuing on Megan's theme, all of these cases also involved failures to comply with supervisory obligations. So the first case I'm going to mention, interestingly enough, is the first time I'm aware of where the commission has enforced MSRB Rule G13 on quotations and MSRB Rule G14 on reports of sales or purchases, which I think is highlighted by both Jean and Megan as something that FINRA examiners look at regularly and enforce. So on October 16th of 2024, the commission charged that AGP Alliance Global Partners engaged in unfair practices in connection with its municipal securities business by quoting municipal bonds at above market prices and facilitating the sale of bonds at above market prices that were also unfair and unreasonable on behalf of a customer. Alliance consented to the SEC's order, finding that it violated MSRB rules G13, G14, also G17 fair dealing, G27 supervision, and G30 fair pricing. I think there's two key takeaways from this case I really want to highlight. The first one is have a clear understanding how your dealer regulatory obligations are modified when you're dealing with a customer who is a sophisticated municipal market participant or SMMP. And two, to make sure the corresponding provisions in your WSPs regarding such modifications are reasonably designed to ensure compliance with the underlying regulatory obligation. So first, starting out with quotations, between February of 2019 and February 2021, Alliance published quotes on a daily basis for between 4,300 and 6,500 different municipal bonds at above market prices on several electronic municipal bond platforms for a customer that was an SMMP without independently evaluating the fair market value of the bonds at the time it made the quotations. It deferred to the judgment of its customer. So depending on the facts, that could be okay. A dealer may publish quotes on behalf of another dealer or an SMMP so long as they have no reason to believe the price stated in the quotations is not based on the best judgment of the fair market value of the securities of that dealer or the SMMP. Nice double negative there in the rule. Alliance did have reason to believe the quotations were not based on the customer's best judgment of the fair market value. Every day the customer would send over a list of the thousands of CUSIPs it wanted quotes published for, along with an adjustment for each bond to be used in generating the quotes. The customer subscribed to an industry recognized pricing service, and they knew what the evaluated price of the bonds were. The adjustment was devised by the customer to ensure the price of each bond was above the fair market value. The customer explicitly informed Alliance in instant messages and other communications that the quoted yields had to be at a minimum 25 to 30 basis points lower than the yields corresponding to the pricing service, thereby ensuring the quoted prices would be higher than the pricing service prices for the bonds. Based on these facts, Alliance was obligated to independently evaluate the fair market value of the bond of the quotes. Second, turning to fair pricing, Alliance also facilitated sales attributable to the quotes in a principal capacity on 204 occasions without evaluating the prevailing market price, or the PMP, of the bonds or determining if the aggregate prices it was paying the SMMP were fair and reasonable. So there is an exception to the G30 fair pricing obligations for an SMMP customer, but it is for transactions, not for principal transactions, but for transactions that are non-recommended agency transactions, where the dealer's services are limited to providing anonymity, communication, order matching, and/or clearance function, and the dealer does not exercise discretion as to how or when the transactions are executed. So this exception was not available based on the fact pattern that we were dealing with. Third, turning to trade reporting, which Megan just spent some time talking about. On at least 51 instances, Alliance paid its SMMP customer above market prices that were unfair and unreasonable, and failed to identify those trades as away from the market when it reported them to the MSRB's real-time transaction reporting system for display on EMMA. So Alliance's pricing failures created the risk that other participants in the market relied on the inflated prices to value same or similar bonds. And then I think fourth I want to mention is fair dealing. While Alliance's pricing failures benefited the SMMP customer because it paid above market and in some instances unfair and unreasonable prices, it adversely affected other participants in the municipal bond market.
The dealers who acquired the bonds from Alliance directly or indirectly through interdealer trades marked them up and then passed on the inflated prices to their customers. Turning on to the next topic, I want to mention a couple cases in the regulation BI space. And interestingly enough, these both deal with 529 college savings plans and municipal fund securities, which I think Jean spent some time on describing as a FINRA exam priority for this year. So the first one involves Thrivent Investment Management, and I really think there's two key takeaways for this case. The first one is if you rely on a share class calculator to make your recommendations to customers, make sure you have a process in place to keep it up to date. And the second theme I want to mention is the significant impact of self-reporting and remediation. So on October 2nd of 2024, the Commission charged Thrivent Investment Management with failure to comply with regulation best interests in connection with its recommendation to certain retail brokerage customers to invest in Class A mutual funds instead of Class C mutual fund shares offered by both a Nebraska and an Illinois 529 college savings plans. So the Class A shares imposed upfront sales charges as well as annual fees. And the Class C mutual funds did not impose upfront sales charges, but they charge higher annual fees than the Class A shares for the first 10 years of the investment, at which time they converted to Class A shares. During the relevant period, Thrivent and its representatives utilized a share class calculator to determine which mutual fund share classes to recommend to customers. While historically it might have been in the best interest of many of their customers to invest in the Class A shares of the Illinois 529 plan and the Nebraska 529 plan, both made changes to their expense structures in March 2020 and December 2020, respectively, that significantly reduced the annual fees charged on the Class C shares. Until July of 2022, Thrivent failed to update its calculator to account for these expense structure changes implemented in 2020, and as a result, recommended Class A shares to many of its customers. As a result of this failure to understand the difference in the costs, they failed to exercise reasonable diligence, care, and skill when recommending investment in these college savings plans to retail customers. So interestingly, here, which I was highlighting earlier, Thrivent's remedial actions were very notable. Thrivent promptly identified and reported the facts concerning the violations to examination staff during an ongoing exam. They conducted their own internal investigation and analysis. They revised their WSPs, and they paid approximately $220,000 to $800 to 846 retail customers, representing the upfront sales charges plus interest these customers had paid. So they ended up with a civil penalty of $25,000. So turning on to the second Reg BI case, and this was a case involving State Farm VP Management. I'll start with my key takeaways again here. And I think in the 529 municipal fund security context, it may be important not only to consider any material limitations on what you can recommend through your platform, which may be quite limited, but also to take into consideration which state your retail customer lives in and whether an in-state plan offers tax advantages. So on September 16th of this year, the Commission charged State Farm with failure to comply with Regulation BI in connection with its recommendation that certain retail brokerage customers invest in State Farm's Nebraska 529 plan. So State Farm recommended the Nebraska plan to customers who did not reside in the state of Nebraska and who forwent tax benefits provided by their home state's qualified tuition programs. Also, the Nebraska Savings Plan only offered Class A and Class P shares of two mutual fund companies, each with upfront sales charges. State Farm recommended these to customers who expressed short-term investment horizons or liquidity needs, and State Farm failed to disclose the material limitations of securities available on its platform and its resulting conflict of interest in recommending investments in these mutual fund offerings. So State Farm consented to the SEC's cease and desist order, finding it violated Regulation BI. It did pay $422,000 in interest back to reimburse affected customers, and it had a civil penalty of $211,000, so significantly higher than the other firm that self-reported. So turning to the topic of municipal advisors, the main case I wanted to mention today is a fiduciary duty case involving the conflicts of interests. As Tina highlighted earlier, fiduciary duty and MSRB Rule G42 are exam priorities for fiscal year 2025. I think, Jean also highlighted this is something also that FINRA is looking at. On October 24th of this year, the commission charged Hamlin Capital Advisors and Michael Fowler-Braun with failure to timely and fully disclose material conflicts of interest and related violations of MSRB rules, and Hamlin Capital Advisors with breaching its statutory fiduciary duty with its disclosure violations. So a couple key takeaways here. I think the first is this case really highlights the importance of disclosing material conflicts of interest in writing prior to or upon engaging in your municipal advisory activities. It's not going to be enough if exams come or enforcements come and says, oh, well, I told them all about that and no one has any recollection of it. It has to be in writing for a rule, and it's protective of you all to provide it in writing. Second, and I think my co-panelists have both spoken about this already, is the importance that disclosures of conflicts of interest must be sufficiently detailed to inform the client of the nature, implications, and potential consequences of each conflict, and include an explanation of how the municipal advisor addresses or intends to manage or mitigate each conflict. And you all may be very well familiar with that language because it's in supplementary paragraph 5 to Rule G42, explaining what needs to go into your conflicts of interest disclosure. So between September 2017 and April of 2022, Hamlin Advisors and Braun provided advice to certain charter schools on the issuance of municipal bond offerings, totaling over $500 million in aggregate principal amount. In each of these issuances, Hamlin Advisors affiliate, a registered investment advisor, purchased either all or a substantial portion of the bonds. In most instances, Hamlin's affiliate also acts as a compensated bondholder representative. So this affiliate relationship created a material conflict of interest which was not timely disclosed to the charter school clients until several days or sometimes weeks after Hamlin Advisors began advising on the structure, timing, and terms of the deals. And when Hamlin Advisors did disclose that a material conflict of interest existed, the disclosure was inadequate because it only said that the firms had certain common ownership and both firms could receive fees. It did not disclose that Hamlin Advisors had a financial incentive that was opposed to the interests of its clients due to its affiliation with the Hamlin affiliate that was going to purchase the bonds and in some instances act as the compensated bondholder representative. Further, Hamlin Advisors' disclosure was inadequate because it did not describe the nature, implications, and potential consequences of the conflict or how they plan to manage and mitigate the conflict. In addition, in their advisory agreement with the charter school clients, advisors did not accurately describe the scope of the municipal advisory services for the deals at issue. For example, an advisory agreement stated that the client considered various financing structures and elected to proceed with the financing structure associated with the bonds without the assistance of Hamlin Advisors, and Hamlin Advisors did not provide any assurances regarding the merits of the structure. This was inaccurate because Hamlin Advisors did in fact provide advice on the financing structure. Finally, as I was kind of highlighting at the beginning, Hamlin Advisors' written supervisory procedures were not reasonably designed to achieve compliance with applicable rules. In particular, the WSP stated that Hamlin Advisors' clients would be the 501c3 organization or other entities that managed the charter school or in some instances acted as kind of the conduit borrower holding title to a charter school facility and not municipal entities. And this is really important because you only owe a fiduciary duty if your client is a municipal entity. And this WSP was not accurate because they were providing advice directly to the charter schools, or in other instances to or on behalf of the charter schools through these other entities. As a reminder, the municipal advisory regime covers advice to or on behalf of municipal entities. It covers indirect advice. You can't avoid a fiduciary obligation by passing your advice through another organization. So Hamlin Advisors consented to the SEC's cease and persist order, finding that it violated statutory fiduciary duty, MSRB rules G17, G42A II, B, C, and G44. And Braun consented to an SEC cease and desist order, finding he violated MSRB rules G17 and G42, B, and C. I was.
Yeah, we
We're
are,
on time?
yeah,
Okay.
the bell just rang. So
All right, well, I'm gonna wrap it up. And luckily, the other case I was gonna mention was covered by Mary Simpkins in panel 3. And that was a case involving unregistered MA activity. And so I'm just gonna add on to the pitch made by Mary and say that in the charter school space in particular, we have brought multiple matters now where we've found firms engaging in unregistered municipal advisor activity. They start out in consulting roles as real estate developers, and then they kind of tiptoe and wander over into helping their clients figure out how to finance those real estate developments and school buildings with tax exempt bonds. And so I also encourage folks who see unregistered municipal advisory activity to feel free to reach out to me directly, or to use the SEC's TCR system, where you can anonymously submit a tip if you see unregistered municipal advisory activity.
Thank you. Thank you all so much. I was asked to remind you to bring your badges tomorrow. So wear your badges again tomorrow. Over to Bree to close it out.
Sit tight for a couple more announcements. So thank you all to today's panelists, and thank you for your engagement as audience participants, for your thoughtful questions. And we will see you back tomorrow for day 2. As a reminder, tomorrow's sessions start at 8:20 a.m. Mountain Time. Also, as a reminder, do not forget that you can request office hours or time to pull one of the regulatory agencies aside for additional questions or specific firm matters based on today's conversation. So please do take advantage of the ability to pull us aside for office hours. Thank you and have a good night.